What is up? It's iCkEdMeL. It's been a while. I'm back, somewhat back, pretty much back. And there's supposed to be this hearing today with the Petito family and the Laundrie family. The live stream is supposed to be starting like around 1:30. And I'm going to try to find a feed that we can use. Hopefully there's no issues. And I'm going to play some video clips and kind of talk a little bit about this. Let me see if my setup. Oop. Knew that was going to happen. I feel like it's been a while. No. There we go. And okay, there we go. What's up? How you guys doing? It's been so long, I feel like, since we've kind of talked about Gabby and this whole story and the situation. I was kind of reading a little bit of the article to kind of recap myself a little bit. Oh, that sucks, like he's popping up. But so this is just a pretrial, and this is Petito and Schmidt have filed a lawsuit on the grounds of intentional infliction of emotional distress. They were saying that the Laundrie family knew about Gabby's death like prior to being announced, like that the son had told them. I wish I could get rid of this thing here. It says the lawsuit includes the allegation that Chris and Roberta Laundrie were told by their son of Petito's murder on or about August 28th. And let me see here. Gabby was reported missing September 11th, according to the note that I have here. But they haven't shown any proof of this. This is their claims. It says that it's believed that, therefore, averred that Brian Laundrie advised his parents, Christopher Laundrie and Roberta, that he had murdered Gabrielle, the lawsuit states, on the same date that Chris and Roberta retained Stephen Bertolino, the attorney. So they believe that they're saying that he had told his parents, and then that's when they got the lawyer. Let me play this little clip right here. What's up? Oh, wait. Oh, you guys don't have audio. 1 second. Everything kind of got jacked up for some reason, since I haven't used my computer in a bit. All right, let me see if you guys have audio.
Brian Laundrie. And what happened after that turned into a months-long mystery, then a manhunt that eventually ended tragically with both Gabby and Brian dead. There are many things about this case and the relationship that we will never know, but there is one question that we may finally have answers to. How much did Brian Laundrie's parents, Chris and Roberta Laundrie, know about what happened to Gabby? They may have to reveal that as part of a lawsuit filed against them by the parents of Gabby Petito that will be getting underway tomorrow. Senior national correspondent Brian Nenton has been following.
I think I got a feed for us too, which is amazing. Let's see. Yeah, amazing. All right, guys. So I have a feed, and they haven't started yet, but let me see if I can put this up on the side. So when we watch the videos, we know what's going on before they start. Let's see here. All right. And just kind of bear with me a little bit, guys. Sorry, it's been a while since I've even live streamed or even covered something besides Johnny Depp. Feels kind of weird almost.
Following this story since the very beginning, and he is joining us tonight. Brian, I guess the biggest thing is help us map out what we can expect at tomorrow's hearing. The first, that there will be a lot of tension on the Laundrie parents.
Yeah, Marnie, I think you really hit the nail on the head on why this is such a big deal and why this civil case could be so important. It's because we haven't heard from the Laundries. They haven't said really a word since all of this began, besides statements to their attorney. So if this ends up moving forward and going to trial, they could be required to testify. There would be discovery. Evidence would come forward. We might finally get some of the answers that we've all been waiting for. But it's a very big if this moves forward. And that is what the judge is going to.
So I was wondering that too. Do you guys think this will move forward? I mean, I know we haven't heard it yet. If it doesn't move forward, then that's it. I believe they filed 2 motions. I think the Laundrie family to dismiss. We'll take a look at the article. And they're saying that the Laundries are not, they don't think they're going to show up, which they don't need to. They could just send the attorney to represent them. What's up, Bridget? Debbie, Chrissy, how you guys doing? Please hit like. I'd appreciate that. Egypt Mania, how you doing? BL, Miyu, Queen, welcome. Thanks for chilling with me, guys.
Talk about and possibly decide on tomorrow. The Laundrie's attorney has asked for all of this to be thrown out. The Petitos are claiming that the Laundries caused pain and suffering. But the Laundrie's attorney says, look, they didn't have to talk. We chose for them to remain silent. That is a right of every American. And they're going to say, look, this needs to be tossed out. And the judge will decide tomorrow.
Right, Steve.
Because they're saying that the Laundrie family had the right to remain silent. But I don't know how, if the evidence is true, I don't know. If they prove the evidence, they show the evidence, if they knew about the murder, then that doesn't protect them, right? But can they prove that?
Bertolino, the attorney for the Laundrie, is calling the lawsuit baseless, and he says that Steve and Roberta did what everyone else should and would do in the same situation. There will be cameras allowed in the courtroom tomorrow. Will the families be present?
We don't know. It's our understanding that the Laundries will likely not be there, that their attorneys will just be there for them, which is really no surprise in light of sort of the way that they've been portrayed over the last year or so, that they would want to avoid the limelight and all the cameras that'll be outside.
They said that, who said that? Amber said, is Bertolino representing Roberta? So Bertolino's coming in. He doesn't have a license in Florida, but he's, I hear he's going to come in through webcam or something like that. I don't know.
In terms of whether.
But I think they have different attorneys, I believe, but he is going to be there on camera, I believe.
The Petitos will be there.
And we'll take a look too. There's a witness list. We can take a look at that as well. This is supposed to last about an hour today, so it's not going to be long. This is like the first pre-trial hearing to determine whether it's going to go forward or not. So, but the Petitos obviously are there, but the Laundries aren't going to be there.
We don't know at this point. It's possible they will be. They may be wanting to send a message. There was at one point during this process that the judge said that they needed to beef up their lawsuit if they didn't want it to be thrown out, which they did. So tomorrow they're really going to be fighting for this to remain in the court system.
Right. And in doing so, they say they have new evidence to back up their case and their claims. Any indication what that evidence might be?
I forgot.
Yeah, which is very.
I forgot Pussycat was there in the corner. She might be a permanent add-on to the channel. I'm not sure. We'll see. But I forgot she was there.
Very interesting. They haven't let on what that new evidence is. But again, that is what would be so fascinating about this process if it moves forward, is all of that would come out. The FBI would reveal what they have to the court. The Petito family would reveal what they know. They met with the FBI. Remember, Marty, they spent hours meeting with the FBI when the case was closed and getting all sorts of information that we don't know about. All of that would likely come out if this civil trial moves forward.
The other thing, Brian, is Gabby's parents' attorney put forth this wish list of potential witnesses in the case. Who all's on it?
Yeah, I was just going over the list. It's really no one that surprised me that much. It's sort of you'd expect Gabby's parents, mom and dad and the step parents, Christopher and Roberta Laundrie, which again would be very, very interesting if they were required to talk. Of course, they could plead the fifth, but if they had to sit down at a deposition for the first time to hear what they have to say, would certainly be enlightening. And then representatives of the FBI and of the Northport Police Department. FBI, you remember, Marnie, they put out that closeout memo when they closed out the case with some new details, but there's still so much they didn't say publicly. So if they were required to testify, again, we would just learn so much more about it.
And I'm actually seeing a feed that has better quality. So let's get the gangster quality. Give me 1 second. Let me just fix it. I wanna have a better one on the screen. How you guys been, man? I just came back from Cali, by the way. I was in California visiting. I want to go back. I had a lot of fun. And I've been kind of like on a break this entire time. I've been popping in and out just doing the chases, but that's not real content to me. So I think I'm ready to come back. Ready to start covering some. This one's better. Some true crime stuff. And we got to decide too what's going to be the next trial as well. Is Molly in the courtroom? Nah. No Molly. Hopefully it's not a problem.
About all of this.
So if the judge dismisses the case, which in all likelihood that's a real possibility, then what, Brian? Is that the end?
It is a real possibility.
Brown,
and I think it's good you said that, because so many of us who are passionate about this case and want the information and feel terrible for the Petitos, we all have to realize that that is a possibility. So many of the attorneys that I've interviewed, legal analysts say, look, it's almost likely that this could possibly get thrown out because the Laundries did have the right to remain silent and did not have to come forward if that's what their lawyer was telling them to do. But of course, there's also a chance that this could move forward. And if it does, again, that's when we would likely learn a lot of new information.
I mean, it's going to be interesting to see what they're going to bring up. I guess they're going to have to bring that evidence, I guess, forward. Let me look at the article again real quick. So the lawsuit says that, yeah, Chris and Roberta Laundrie were told by their son about Petito's murder on August 28th. And Brian advised his parents, Chris and Roberta, that he murdered Gabrielle. The lawsuit states on the same day Chris and Roberta spoke with Steve Bertolino. The other thing, too, as you guys might remember, like, these people supposedly had blocked the Petitos. I think, like, on Facebook, blocked their phone number. They weren't answering calls. I mean, I guess they didn't have to say anything to them legally. Pretty jacked up. And I want to put this up top. It's about to be 1:30, so they're going to start soon. Yeah, all right, let me switch screens here. Let's see. I think I'm going to switch screens. Get this one on the big screen here. Kay, thanks for being a member for 9 months. Happy to be back. Enjoy your time off. Thanks, Kay. Appreciate it. Hey, Kasi, we got to talk. We got to talk. So, yeah, they're getting ready to start. I was looking at the timeline a little bit. I used to have a really gangster timeline, a timeline plug.
Seated, everybody.
There we go. But that link doesn't work anymore.
And good afternoon. I am electronically present in the courtroom today as I'm abiding by the court's quarantine protocols. We have technology in place to allow the court's work to continue without delay. My preparation for all hearings today, not simply these two cases, has been the same. The court is prepared. Whether you are joining us in person in the courtroom or via Zoom, welcome. There are two housekeeping items to address.
Judge ain't even there?
First, only credentialed media authorized by the court's public information officer, as well as the court reporter, may record these proceedings in the courtroom or on Zoom. If you have not received that authorization in advance, you may not record these proceedings.
What?
Second, we have two cases this afternoon. The first case we will address involves the parents as parties in the lawsuit. We will complete that hearing before moving on to the second case, which is the case involving the estates. So let's begin. The court's going to first call the case of Joseph Petito and Nicole Schmidt versus Christopher Laundrie and Roberta Laundrie, case number 2022 CA 1128. Ask the attorneys to please make their appearances and introduce their clients if they're present.
Good afternoon, Your Honor. Patrick Riley Ford, sitting to my right, Joseph Petito.
How's the
Also
volume,
sitting
guys?
to my right, Nicole.
Can I pull it up a little bit more? I can boost it up a little more. I don't want too much background noise.
Mr. Luca?
Good afternoon, Your Honor. Matt Luca on behalf of the defendants, Christopher and Roberta Laundrie, who are not present.
Not present.
Thank you very much. Now we are to hear the motion to dismiss filed by the Laundries, which is at document identification number, or DIN 33. The plaintiffs have filed a response, which is at DIN 38, and the defendants have filed a reply, which is at DIN 39. I've reviewed those filings as well as the other materials submitted by the parties. So, Mr. Luca, you have the floor, and if you'd like to go to the lectern, that would be great.
Yes, thank you, Your Honor.
So this is the laundry
I have to say, Your
attorney.
Honor, it's unusual to be staring at an empty spot up there at the bench.
It's weird. Shouldn't the
Well,
judge be
it
required
is
to
what
be
it
there?
is.
The hell is this? What are you, AI?
What do they tell
The metaverse?
actors, Your Honor? Just find a place on the wall and stare at that?
Yeah, what is this shit?
Well, thank
Judge
you, Your Honor,
Becker?
for your time this afternoon. I appreciate it. Your Honor, I won't spend any time going through the general standard on a motion to dismiss. I know Your Honor is well aware of that, so I'll just jump right in. Your Honor, our position is straightforward. A cause of action for intentional infliction of emotional distress was not intended to include liability for a defendant who does nothing, who has no contact with the plaintiff. All of our arguments regarding outrageousness, legally permissible conduct, causation, and the presence of the plaintiff all go back to that premise and show why there is no legal footing for this cause of action in this context. Conduct that amounts to remaining silent and maintaining privacy is not intentional infliction of emotional distress. And there are no cases where such conduct was found to be intentional infliction of emotional distress. Rather, plaintiffs argue that the Laundries had an obligation, a duty to speak. The law imposes no such obligation to speak, and the state and federal constitutions support that. In our society, under our laws, people are free not to speak. Your Honor, the elements of the cause of action alleged are a deliberate or reckless infliction of mental suffering, outrageous conduct, the conduct caused the emotional distress, and the distress was severe. I'll first address the outrageous conduct element, Your Honor. So the standard for determining whether or not conduct is outrageous is that the behavior claimed to constitute the intentional infliction of emotional distress must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. That is conduct that is atrocious and utterly intolerable in a civilized society. It is an objective standard, and the subjective response of the plaintiffs is not what controls. The issue of whether or not conduct is outrageous is a question of law and for the court to decide. And that standard is extremely high in Florida. It is not enough that the defendant acted with an intent which is tortious or even criminal, or that the defendant intended to inflict emotional distress, or even that the defendant's conduct can be characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. Now, Your Honor, looking at the amended complaint in this case, paragraph 32 provides a summary of what the plaintiffs alleged is the conduct that was outrageous. So they allege, first, failing to advise the plaintiffs that Ms. Petito was deceased. Second, failing to disclose to the plaintiffs the location of Ms. Petito's body. Third, taking a family vacation with their son, Brian Laundrie, who they allege had murdered Ms. Petito while the plaintiffs were looking for Ms. Petito.
Vacation was sus.
Fourth, blocking access to their cell phone and Facebook page to preclude the plaintiffs from contacting them and getting information regarding Ms. Petito. And finally, that the Laundrie's attorney, not the Laundries themselves, issued a statement to the press expressing hope that the search for Ms. Petito is successful and that Ms. Petito is reunited with her family.
Is there a distinction between the attorney doing it on behalf of the Laundries versus the Laundries?
Well, Your Honor, the attorney is obviously not a defendant in this case, and there are no allegations that within the complaint that the Laundries directed the attorney to make that statement, what information the attorney had with regard to making that statement. So I do believe that there is a distinction, Your Honor.
Isn't under Florida law, isn't the attorney the agent of the client?
I do agree with that, Your Honor.
Then why does it matter that the attorney and not the Laundries themselves made the statement?
Well, Your Honor, what we don't know, what is not alleged in the complaint, is whether their attorney was making that statement on behalf of the Laundries or whether he was making that statement in his personal capacity.
Well, on a motion to dismiss, how am I supposed to construe the well-pled allegations?
Your Honor, on a motion to dismiss, I would argue to the court that by not alleging in the complaint that the attorney was the agent of the plaintiff, or, I'm sorry, of the defendants for purposes of making that statement, that the plaintiffs have not alleged sufficient conduct that would cause liability for the defendants for the statement by their attorney.
Well, assume for the sake of argument, the court concludes that there was sufficient allegations that the attorney is the agent for the Laundrie. So assume that to be true. Now we have a situation where the Laundries themselves are making a statement and not standing silent. So what does that do to your argument about staying silent?
Your Honor, I still don't think it necessarily makes a difference. I mean, I understand what the court's saying, that if we impute that statement to the defendants, that would not be complete silence by them. However, the defendants do have a constitutional right to have an attorney and to have that attorney speak. So again, Your Honor, in my view, the attorney was merely exercising the constitutional rights of both the attorney and of his clients by making a statement.
Okay, but when you make an affirmative statement, that's the antithesis of staying silent, right?
I would agree with that, Your Honor, yes.
You may continue.
Thank you.
Uh-oh. Oh, look, he's buying it.
Your Honor, the plaintiff's claim of outrageous conduct in this context is novel.
Amber's team.
The plaintiffs have cited no cases where a person's silence, except with regard to what Your Honor just raised with regard to their attorney's statement, was considered outrageous, regardless of the circumstances. And they certainly haven't cited any cases where a statement by a person's attorney has been considered outrageous. All of the cases they've cited involve some action by the defendant. Accepting the allegations of the amended complaint as true and allowing the case to proceed further would require any person and their family to speak about an alleged crime or other tragic event of which they may or may not possess knowledge, and that is simply not something that our legal system requires. For example, if a family member came to me and told me that they did something terrible, the plaintiffs want the law to impose an obligation on me to then report what that family member told me. And that just isn't the law. Even if that I'm sorry, go ahead.
Let me make sure I understand what you're saying. Are you saying that they came to you in your capacity as a lawyer or as just a normal person?
Just a normal person, Your Honor, just a family member.
Okay, well, does Florida recognize a privilege, a parent-child privilege?
Your Honor, I'm not arguing privilege. This could be somebody who is not a parent, a child, a wife, a husband, just anybody. My argument is not that there was a privilege between Brian Laundrie and his parents. My argument is that even if Brian Laundrie conveyed information to his parents, that they don't have a requirement then to speak with regard to that information. They don't have to share it.
Okay, well, let's go down that road for a moment, because this is where I'm having some difficulty. I fully understand and get the constitutional right to remain silent. That being said, we're on a motion to dismiss on a complaint where I have to assume the facts are true. And you're trying to get me to say that the complaint itself demonstrates the existence of a right to remain silent. And I'm trying to understand how that is, or is that more of an affirmative defense that should be fleshed out in the pleadings?
Your Honor, I don't agree that it's an affirmative defense that needs to be fleshed out. I believe the court can, obviously the complaint alleges that the defendants were residents of the state of Florida, so the Constitution of Florida and the Constitution of the United States apply to them. And if you look at the complaint, Your Honor, even though it doesn't allege a formal criminal investigation, it doesn't use those magic words, so to speak, it does allege that Brian Laundrie murdered Ms. Petito. It alleges that Brian Laundrie engaged in conduct to try to cover that up by sending text messages and things like that. It alleges that the defendants, his parents, the Laundries, were trying to help him escape the country. It alleges that the Laundrie family hired an attorney, and then once they hired the attorney, at that point, all the contact with the plaintiff stopped. And the only statement we have is that one statement by their attorney that the court referenced. So under those circumstances, as alleged in the complaint, Your Honor, that's enough for the court to say somebody in that situation could invoke their Fifth Amendment privilege. That's not something that the court would need to find additional facts. The court does not need to look outside the four corners of the complaint. There are sufficient allegations within the complaint that would trigger somebody in that situation exercising their Fifth Amendment privilege. Your Honor, would you prefer for me to continue with the outrageous element or move on to the legally permissible element, since that seems to be
Whichever way you want to go.
Okay, thank you, Your Honor.
I'm not shy in asking questions.
I understand. Your Honor, the plaintiff's cause of action could also extend to somebody who, may not be in the situation where they were told something, but maybe they witnessed something, or maybe they came upon some evidence, or somehow they had some information that might be relevant to some tragic event. The plaintiff's cause of action would impose an obligation on people like that to contact the families who may be involved in that situation and disclose what they knew, or they would fear being sued. The slippery slope of allowing this cause of action to proceed would really require anyone with knowledge of events that are hurtful or which cause emotional distress to another to convey their knowledge or potentially be exposed to liability. Now, the underlying crime.
But again, I go back to, there's an allegation that the Laundries made an affirmative statement and put out into the public various statements. So am I not supposed to consider that conduct, because that's a voluntary act by the Laundries?
I understand, Your Honor, and I assume you're referring to the one statement by the attorney alleged in the complaint. Assuming for the sake of argument that is an affirmative statement by the Laundries, Your Honor, you can definitely consider that. But again, in the context of the overall case, is that statement alone sufficient to meet the standard for outrageousness? If, let's say, for example, I had some knowledge about a crime that somebody committed, and I made a public statement about some aspect of that case, but I didn't share everything that I knew, or I hedged my bet, so to speak. Would I then be subject to liability because I shared something but I didn't share other things? That's really the question, Your Honor. Is what are we going to require of people in a situation like this? Are we going to require them to say everything that they know, or are they going to be allowed to speak freely or not speak at all? That's really the question before Your Honor. And Your Honor, I think it's important to keep in mind the standard that we're talking about here, that the conduct has to be atrocious and utterly intolerable in a civilized society. You know, people who are faced with difficult challenges have to make difficult choices. In our society, which I would propose is civilized, recognizes at its core that things like remaining silent or speaking through an attorney are foundational rights. And those are choices that our society considers entirely tolerable. And in fact, they're codified in our founding documents. So, Your Honor, even considering the statement by the attorney, I would submit to Your Honor that's not atrocious, it's not intolerable in a civilized society for their attorney to make a statement for them like that. Your Honor, another thing I'd like to address that the plaintiffs raised in their response is that the Laundries were somehow in an unequal position to the plaintiffs, and that made their conduct particularly outrageous. Your Honor, I don't think that the standard for unequal positions is really what the plaintiffs would qualify that under this circumstance. Your Honor, in Dependable Life Insurance Company versus Harris, which is a 5th DCA case from 1987, it's cited in our papers. Your Honor, in that case, and what the plaintiffs rely upon is restatement of torts, section 46, subsection E, which states this unequal position argument. And what the restatement says is, the extreme and outrageous character of the conduct may arise from an abuse by the actor of a position or a relation with another which gives him actual or apparent authority over the other or the power to affect his interests. Thus, an attempt to extort money by a threat of arrest may make the actor liable even where the arrest or the threat alone would not do so. In particular, police officers, school authorities, landlords, and collecting creditors have been held liable for extreme abuse of their position. Even in such cases, however, the annoyances that are not extreme, even in such cases, however, the actor has not been held liable for mere insults, indignities, or annoyances that are not extreme or outrageous. So, Your Honor, in Harris, what the court recognized there is that the result of this unequal position must be something that is akin to extortion, meaning that somebody threatens another person based upon their position to cause some harm, like, you know, I'm gonna cause you to lose your job, I'm gonna cause you to be arrested, I'm gonna hurt your family, something like that. That's really what it's about. It's about somebody who has some authority to affect the person's life. It's not a situation where somebody might have information that another person doesn't have and they simply don't share it. That's not really what the Harris case or what the restatement are talking about when they say unequal positions. Now, Your Honor, moving on to the assertion of illegal rights. The standard with regard to that element is that the conduct, although it would otherwise be extreme and outrageous, may be privileged under the circumstances. And the actor is never liable, for example, where he has done no more than insist upon his legal rights in a permissible way, even though he is well aware that such insistence is certain to cause emotional distress. Now, we have several rights at play here, Your Honor. You brought up one earlier, the Fifth Amendment right to remain silent. That is certainly one of them. There's also the First Amendment right of freedom of thought, which would include both the right to speak freely and the right to not speak at all. And that was cited in Woolley versus Maynard, a Supreme Court case from 1977. Again, it's in our papers.
Aren't we responsible for the words that we say when we say them?
I would agree with that, Your Honor, certainly. Certainly, if you say words...
Johnny Depp just got found civilly liable for defamation by what his attorney said, right?
Well, Johnny Depp.
Again, Your Honor, I understand that in certain contexts, the statements of an attorney could potentially be, lead to something like defamation. I agree with you on that. I think really what we're talking about here, though, Your Honor, is a statement by an attorney that even in and of itself is certainly not defamation, and it is not outrageous.
My understanding of the statement, and correct me if I'm wrong, is the Laundries knew, and again, this is on a motion to dismiss, so I have to accept what is alleged as true. Not that it is true, but I have to accept it as true. That the Laundries knew where the Gabby's body was, and they put out a statement in the middle of the search, hoping about the success of that search, and then not either directing them or either staying silent. I mean, that's kind of my understanding of what is being alleged. Is that correct, or am I misunderstanding?
No, I believe that's my understanding as well, Your Honor, that the attorney made the statement while the search was ongoing.
And knowing exactly where the Gabby's body was.
Well, Your Honor, again, that's the rub, is the plaintiffs haven't alleged anything in the complaint as to what the attorney's knowledge was when he made that statement. That he had that information.
So did he know?
That's a totally different thing. They've alleged that the parents, the defendants, had that information, but they don't allege that that information was ever shared with the attorney, or that the attorney had that information when he made that statement. That's kind of the issue, is they haven't really made any allegations about the attorney and what he may or may not have known. It's really all about what the parents knew, and they don't make any allegations about what the parents communicated to the attorney. So really the attorney's statement, again, if just looking at it within the four corners of the complaint, there really isn't enough there to say that whether or not when the attorney made that statement, what his knowledge was about any of the facts of the case, frankly. And I would also submit to you, Your Honor, that statement's fairly benign. I mean, I understand in the context that they've alleged, it could be construed as trying to divert attention or something like that. But again, it's a fairly benign statement. I mean, he's really just expressing that he hopes that she returns. And again, they haven't alleged what information he had when he made that statement.
Isn't the context really what's important here? And that's what the second DCA said in that insurance case where the adjuster denied coverage and did so knowing that the person didn't have long to live and just wanted to outlive the person. And the second, which is binding on me, found that to be outrageous conduct.
That is true, though, Your Honor. In that case, the second DCA said that the actions of the insurance company in simply denying the claim, even though they had been ordered by a judge of compensation claims to pay the claim, that in and of itself would not have been outrageous. But what made it outrageous was that there was some sort of internal decision made that they're just not going to pay it for a certain period of time in the hopes that the plaintiff would die. I agree with you that made that particular case rise to the level of outrageousness. Your Honor, frankly, the statement by the attorney in this case doesn't come even close to that level of outrageousness. I mean, you're talking about withholding medical care in the hopes that somebody dies so you don't have to pay for it. I mean, I don't think any of us sitting here would not find that to be outrageous. We're talking about a statement by an attorney, sort of, boilerplate and generic, just expressing that he hopes that the search is successful and whatnot. I don't really equate those two. I mean, I do agree with your point, Your Honor, that the context is important. We do have to consider the context as alleged in the complaint in this situation. But I would just submit to Your Honor that even considering that context within the complaint, the attorney's statement is not outrageous.
You have about 5 minutes left in your argument.
Okay, thank you, Your Honor. So
not looking good, I don't think.
I'll move forward, Your Honor. I know we filed a motion and Your Honor has read it, so I'm not going to try to belabor too many points here. But with regard to the assertion of legal rights, really, the plaintiffs recognize that the Laundries have constitutional rights, and that the conduct that they have alleged within the complaint is really an exercise of those rights. So what they argue in response is that the court on a motion to dismiss shouldn't consider certain things. Number one, because they allege that within the complaint they haven't alleged state action. Number two, that they haven't alleged any constitutional rights within the complaint, and so the court shouldn't consider them. And then fourth, that the constitutional rights are affirmative defenses. Your Honor, with regard to the state action argument, as an initial matter, just because the government isn't trying to compel someone to do something doesn't mean constitutional rights don't go away. If you don't protect your own constitutional rights, even when the government's not trying to do something to you, then you would likely waive them. You know, if the defendants in this case had made a bunch of statements, even if those statements weren't to law enforcement, those statements could absolutely be used against them. So, you know, in that sense, Your Honor, those rights exist, irregardless of whether the state is involved. Your Honor, also, as a second point, there is state action involved here. And one of the cases we cited to Your Honor in our motion sort of sums it up. It's Gerber versus Longboat Harbor, North Condo. It's a Middle District of Florida case from 1991. And that court said, defendant's motion to dismiss is predicated upon its assertion that, since it is not a governmental entity and has not assumed substantially all of the functions of a governmental entity, the provisions of the First Amendment as incorporated in the 14th Amendment simply do not apply. This court cannot agree with defendant's contention, and by applying the principles enumerated in Shelley versus Kramer, which is a Supreme Court case that sort of set forth that the third branch of government, the judicial branch, is also state action. This court found and continues to find that judicial enforcement of private agreements contained in a declaration of condominium constitutes state action and brings the heretofore private conduct within the scope of the 14th Amendment, through which the First Amendment guarantee of free speech is made applicable to the states. Now, obviously, we're not dealing with a contract here or a condo association or anything like that, but the point is the same, that when a party tries to use the courts to enforce something, then there is state action. And in this case, Your Honor, the plaintiffs want the court to enter a judgment against the defendants. They presumably will want the court to enforce that judgment, and they want to use the court's authority to compel the defendants to participate in the discovery process, all of which implicates their First Amendment, Fifth Amendment, all of their rights, Sixth Amendment right to counsel. So, Your Honor, in that regard, there is state action. I addressed the criminal investigation earlier, so I won't go through that again. Your Honor, with regard to the four corners of the complaint argument, like I said before, the Laundries are residents of Florida. It's alleged in the complaint. As such, the Constitution fully applies to them, and the court can consider those rights. You know, the plaintiffs are essentially asking the court to force the defendants to go through discovery, pretrial proceedings, summary judgment, just to get to the point where the court finds that the defendants have constitutional rights. That's just a waste of judicial resources and the resources of the parties. Your Honor, with regard to the affirmative defense, nobody cited any cases where the legally permissible element is labeled an affirmative defense. I certainly haven't seen anything where it's the defendant's burden to prove that if there were to be a trial such that it would be an affirmative defense. You know, rather the legally permissible element is really intertwined with the outrageous element. In the seminal case of Metropolitan Life versus McCarson, which is the Florida Supreme Court case that established the cause of action, the court explained how it applied in that case. And it said, the facts as a matter of law are not so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. Rather, the insurance company, according to the terms of the policy, had the right to demand proof of ineligibility for Medicaid, or from Medicare. And then it goes on and it says, Metropolitan did no more than assert legal rights in a legally permissible way. As such, Metropolitan's actions are privileged under the circumstances. So, Your Honor, it's not really a defense. It's really part of the outrageous calculus, the outrageousness calculus, that the conduct isn't legally outrageous if there is a privilege or a legal right that's being asserted. And Your Honor, we cite some additional cases in our reply that I'll rely upon in that regard. Your Honor also said that even if this is an affirmative defense, which I don't think it is, the court can consider an affirmative defense if it is apparent from the face of the complaint. Your Honor, we would argue that constitutional rights are apparent from the face of the complaint. They allege a crime was committed. They allege an attorney was hired. So it's not a situation where the court can't consider the defendant's constitutional rights. And in fact, in the case Huzzar versus Gross, which we cited in our papers, it's the first DCA case from 1985. It's a defamation case. And in that case, the court was considering a First Amendment privilege on a motion to dismiss and held that trial courts, upon motions to dismiss, routinely make decisions as to whether a privilege applies to protect an allegedly defamatory statement. So again, in that context, the court held that on a motion to dismiss, the court can consider a constitutional right of a defendant if that constitutional right is their defense.
Okay, well let's just ask. I know you have identified what you contend is one crime, which is to actively assist Brian evade capture, essentially. Assuming, of course, that and not this is not within the four corners. I mean, we know outside of the four corners, but not in the four corners. Is there an allegation that there was an arrest warrant out for him? But assume, for the sake of argument, that is sufficient for purposes of us to find that there was some sort of active crime, if you will. Is there any other crime that the Laundries have been accused of or could potentially be accused of? Because before you can invoke a constitutional right to remain silent, there's got to be a crime, right?
Well, Your Honor, there doesn't necessarily have to be a crime. You just have to believe that you may be in jeopardy of a potential investigation.
Well, doesn't the case law talk about it has to be a chain in the causation towards a crime?
Your Honor, I don't disagree with you on that point. What I'm saying, though, is there doesn't have to be a formal investigation. If I left this courtroom and committed a crime and nobody knew about it, I'm not obligated to go confess that crime. Like I can assert my silence for as long as I feel like I need to protect myself.
Well, let me ask you this, because the case law I'm familiar with is in a deposition, the Fifth Amendment would have to be invoked as to each specific question. So, for instance, if the question is, what is your name? You might not have a Fifth Amendment right to not answer that, depending on the context of the alleged crime. So I get back to what is the crime here? And isn't that really something that we need more pleadings to be able to accurately identify so that I have a better standard as to whether or not your Fifth Amendment argument actually is applicable?
I don't think so, Your Honor. Certainly the plaintiffs have alleged criminal conduct, most of which by Brian Laundrie. I'll agree with that. But they do allege that the Laundries, potentially were trying to assist Brian Laundrie in leaving the country, which could be an obstruction, could be something else. There could be, again, we're not leaving the complaint when we talk about that. And so in that regard, the defendants still wouldn't have an obligation to speak about other things that may be sort of tangentially related to the whole situation, if there is potentially a crime involved. I mean, Your Honor, in Miranda versus Arizona, the Supreme Court held the privilege is fulfilled only when the person is guaranteed the right to remain silent unless he chooses to speak in unfettered exercise of his own free will. So it's the defendant's exercise. It's not something where the defendant can maintain his silence only with regard to certain things. If he's not being compelled to answer questions, he doesn't have to speak, period, at all. Again, from Miranda versus Arizona, the privilege has come rightfully to be recognized in part as an individual's substantive right, a right to a private enclave where he may lead a private life. That right is the hallmark of our democracy. So again, Your Honor, it's not, in Miranda versus Arizona, the court wasn't parsing what questions the defendant can or cannot answer. They said the right is a private enclave where a person can lead a private life. They can maintain that privacy for as long as they're able. Now, of course, like there are certain situations if defendant is subpoenaed to testify, perhaps like, certain questions could be parsed, like what the person's name is or something, as long as that's not incriminating, which in some contexts it is. This is, again, going to the plaintiff's argument, they haven't alleged that anybody was compelling anybody to do something and they refused or something like that. In that context, everybody has the right to their private enclave. They don't have to come and affirmatively state everything they know about everything. That's just not the way our society works. It's not the way, it's not how the Constitution works. People are protected until they're not. And so that, in my opinion, Your Honor, I don't believe that the Laundries would have an obligation to provide certain information and not provide other information. That they can withhold all information until it's compelled of them. That's or they're provided immunity by the government or whatever the circumstance might be.
Well, let's put a pin in that right now so I can hear from your opponent.
Yes, Your Honor.
Yeah, that's.
And Your Honor, for our remaining arguments, we'll just rely upon our papers unless the court has some specific questions that you'd like to address.
Thank you, sir.
I don't think it's looking good for him. I don't think the judge is buying or convinced.
Your Honor, this case is not simply about the silence of Christopher and Roberta Laundrie, who knew that their son had brutally murdered Gabby Petito. It's not simply about their callous refusal, despite pleas from the Petito family, to speak up about whether or not Gabby was alive and if she wasn't, where her body was located. It's about a course of conduct that they committed from the moment they learned on August 28th of 2021 that their son had brutally murdered Gabby Petito up until the time that her body was found. And as this court has already noted and pointed out, that includes the statement that was made the one time they decided to speak up. They spoke up through their attorney, and I'll touch upon the importance of that in a little bit. As the court knows, you're bound to accept as true all of the facts alleged in the four corners of the complaint, and I'd just like to review what some of those allegations are.
Well, let me ask you this, Mr. Riley. And let's lay aside the statement that the attorney made on behalf of the Laundries. What duty did the Laundries have to do anything to help Mr. Petito and Ms. Schmidt?
That's a fair question, Your Honor, and I've struggled with the answer to that particular question, and I guess maybe by answering this I'm deflecting, but my answer is this. It's about what they did with the information that they have, not just not disclosing what they knew to the Laundries. And by the way, they could have, to the Petito family, excuse me, they could have made an anonymous phone call and said where the body was located, and that would have helped this situation tremendously. They knew, starting on August 28th of 2021, that Gabby was dead. They knew where Gabby's body was. They knew that the Petito family was desperately searching for information, but they did things affirmatively. They didn't just remain silent. Brian Laundrie came home in Gabby Petito's van by himself to his family's home. That family, knowing that Gabby was dead, knowing their son had murdered her, knowing where the body was, and in particular, knowing that Joseph Petito and Nicole Schmidt were desperate to learn where their daughter was located, they went on vacation. They assumed and continued their normal life as though nothing had happened, while this family was suffering, wanting to know what where their daughter was. Not only did she not.
Let's get back though to legal duty. I hear what you're saying, that these facts might sound bad, but we're not talking about social mores here. We're talking about legal duty.
We're talking.
So let's try to focus in on what duty did the Laundries have? What did they owe to Gabby's parents?
Well, let's put in perspective what the relationship was, Your Honor. These people were not strangers. These people were. Their son was engaged to marry Gabby Petito. Gabby had lived with them for about a year. They had both visited Joseph Petito's home and Nicole Schmidt's home. They were cordial. They had a cordial relationship, a warm and friendly relationship. They knew how much Gabby meant to Joe and to Nicole. Going to the issue of a duty, Your Honor, I struggle with that. Admittedly, it's difficult to say what it is, and that's why I'm saying there was a course of conduct that they did that was outrageous, culminating, in my view, in the statement that was made by their attorney, who, as Your Honor pointed out, is their agent. And what that attorney said in particular is telling. So there's no question that he represented, that he was making that statement on behalf of the Laundries, because he says, it is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming on behalf of the Laundrie family. It is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. That statement was issued with the full knowledge and consent of the Laundries, with the full knowledge on the part of the Laundries that Gabby was not alive and that Gabby's body was located somewhere out west. And instead, they make a statement saying, we hope you find her. We hope you're reunited, giving them false hope that perhaps their daughter is still alive. If that's not outrageous, Your Honor, I don't know what is outrageous. So I think when you talk about their affirmative duty to speak up, I struggle with that. But they did speak up. And when they spoke up, they made that very callous, that very terrible statement, giving hope to Joe and Nicole that perhaps Gabby was still alive, with full knowledge that she was not. And Judge, when I talk about the course of conduct, I want to talk about some of the cases that I cited in my response to the motion where the court found that there was outrageous conduct. And I don't see how any of these cases are by any stretch of the imagination, worse than what happened in this particular case. In the McAlpin versus Sokole case, a patient went to a hospital to have an x-ray done. She put on a hospital gown. She walked into the x-ray room, and the minute she walked into the room, the doctor began berating her in front of other staff because she hadn't paid another doctor's bill. He told her he wasn't going to treat her, and he told her that he was going to call security and have her removed from the hospital. That, according to the court, was outrageous. In Nims versus Harrison, a teacher, two students of the teacher wrote, published, and circulated a newsletter in which they had an article called Low Life, and they referred to that teacher in offensive language, threatened to kill her, threatened to rape her children, and threatened to rape their cousins. Outrageous. Ford Motor Credit Company versus Sheehan. Collection agent is unable to locate the debtor, contacts the debtor's mother, tells the debtor's mother that she's from a hospital out in California. She's trying to locate the debtor because two of the debtor's children had been in a serious car accident, and she wants to find the debtor so that she can let him know about this accident. The son speaks to the mother later that day, hears the story from the mother, spends the next 7 hours calling hospitals and police departments out in California, only to find out that this story was false. That was outrageous. The Dependable Life Insurance Company versus Harris case was talked about previously. In Liberty Mutual versus Stedman, the company delayed authorizing a lung transplant even though a judge of compensation claims had already ordered that they pay for the lung transplant. The carrier knew she would die without the lung transplant, so hoping the problem would go away, they denied payment in an effort to intentionally induce stress on her part to speed up her demise. The court said, under the totality of the circumstances, it's outrageous. Williams versus Mineola, and it's these two last cases that I'm going to cite the court to that I think are most instructive here. In Williams versus Mineola, police officers attended the autopsy of a teenage boy who had been murdered or committed suicide, and they were there with a videotape, a video camera, and a camera to record it because of the suspicion that a crime may have been committed. They took that video, they took those photos, and they took them to a party. And at the party, they shared them with other persons, including other police officers from surrounding jurisdictions, and they laughed and they joked about what was in those photographs. The court found that to be outrageous, and here's what the court said. As for what is outrageous or reckless or what is not, We emphasize that our society, as reflected, for example, in decisions of the courts of Florida cited earlier in this opinion, shows a particular solicitude for the emotional vulnerability of survivors regarding improper behavior toward the dead body of a loved one, and the special deference paid by courts to families' feelings where rights involving dead bodies are concerned is central to our decision. This area is unique, and once it has entered, behavior which in other circumstances might be merely insulting, frivolous, or careless becomes indecent, outrageous, and intolerable. One obvious reason is that the bereaved are already suffering psychic trauma because of the loss of the loved one, and are especially sensitized to any disrespect or indignity directed at the deceased body or a representation of it. The potential for severe emotional distress is enormously increased in that situation. All of this is well known to the ordinary person, and so a level of carelessness or callousness which might not be considered tortious in other situations can show outrageousness and recklessness when a dead body or a picture of a dead body is involved.
Well, Mr. Riley, how is a statement, "We hope this search is successful," how is that in itself outrageous?
It's a lie. It's said with knowledge that there's no hope of finding her alive because she's dead. It's said with an intention to give false hope to a family that their daughter may be alive. That's outrageous. And at this particular point in time, they had been begging the Laundries to tell them where their daughter was, and this is the statement that they issued. The one time they chose to speak up, this was the statement that they issued. A lie that gave false hope to Gabby's parents that perhaps she might be alive. The other case, Your Honor, that I think is instructive is the Thomas versus Hospital Board of Directors case, and I think this one may be even more instructive. In that case, during I believe it was a hip transplant surgery, the decedent died. She died of cardiac arrest. What she really died, the real reason she died of cardiac arrest is because she was given an overdose of a particular medication during the surgery. And the doctors and the nurses agreed that they would not report the true reason for why she died. They would say that it resulted from complications of surgery. As a result, the complete autopsy was not done. The body was released to the family, and less than a week later, as the decedent's daughter was trying to bury her mother, she received a telephone call from the medical examiner saying, "You need to bring that body back immediately. We have to perform a complete autopsy." Again, the court said that was outrageous, and what the court said was, "We believe that the appellee's conduct in making false statements," and isn't that what Mr. Bertolino did on behalf of the Laundries here? "We believe that the appellee's conduct in making false statements which led to the interruption of Mildred Thomas's funeral and the return of her body for a second, more thorough autopsy rises to the level of atrocious and utterly intolerable behavior which cannot be condoned in a civilized society. As noted in Stedman, when an actor has knowledge that the other person is peculiarly susceptible to emotional distress," and the Laundries knew that because this family publicly said they were distressed trying to find their daughter, "the actor's conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge. We believe that in a situation where a person's loved one has died, it would be apparent to anyone that the person would be susceptible to emotional distress, and therefore that the action of providing false information concerning the loved one's cause of death meets the standard for a claim of outrage." In this case, they provided false information, a false impression, knowing that Gabby was dead, that she was still alive and she could be found by the family if they were searching in the right place. So I also think under the restatement of Tort Section 46, comment F says, "The extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. The conduct may become heartless, flagrant, and outrageous when the action proceeds in the face of such knowledge, where it would not be so if he did not know." And that's basically what the Williams court was saying, and that's what I'm saying in this instance. The Laundries knew of the fragile emotional state of Joseph Petito and Nicole Schmidt at the time that that statement was issued. They knew that she was not alive. They knew that the family was hoping to find her, and they put out a statement as though they were supporting them, saying, we know she was our son's fiance, and we hope that you find that body too, or you find her and the family is reunited, excuse me. That's callous. That's callous, it's shameful, and it's outrageous. And by the way, the only reason that Mr. Bertolino is not a defendant in this action is because he's not a citizen of the state of Florida. I think there's also support for our position under comment E to the restatement, which says unequal position of the parties in a relationship where one asserts and has the powers to affect the interest of the other may also supply the heightened degree of outrageousness required for a claim of intentional infliction of emotional distress. Here, the defendants clearly had the power to affect the interests of the plaintiff because they could have told them where her body was located, and they chose not to do so. Your Honor, I don't think there's any question. There's been nothing raised, at least by counsel in his argument, that the conduct didn't cause severe emotional distress to my clients, to the extent that they would suggest and have suggested, well, they were already distressed anyway, so all we did was increase their harm. I guess it's okay to kick someone when they're down, according to the Laundries. But going back to those two cases that I cited earlier involving dead bodies, the parties were already grieving, and it was the conduct after death that the court found was outrageous and permitted the case to move forward. So I think we have the issue of their conduct was intended to harm, or certainly what they did, they should have known was likely to cause severe emotional distress to my clients. We clearly have an outrageous conduct on their part. I think we have established that the conduct caused more emotional distress. It doesn't have to be the only cause of their distress. If it increases, that's sufficient to recover. And I don't think they're contesting at all that the emotional distress was severe. So I'll move on to the suggestion that the defendants get to raise affirmative defenses at this point in time.
Well, and thank you for doing that, because my question there is, I mean, the rule is that I can address it if it is apparent within the four corners, and effectively you alleged conduct which arguably could be considered criminal on behalf of the defendants. So why can't I consider the Laundrie's constitutional right to remain silent and other constitutional rights within the context of ruling on this motion to dismiss?
Well, Judge, I'm curious to find out what conduct it is that the complaint says the Laundries committed that was potentially criminal. So if the answer is they were harboring a fugitive, there were no charge. Again, we're outside the record, but to my knowledge, or outside the four corners of the complaint, but the complaint doesn't allege that there were any charges pending against Brian Laundrie at the time. So they couldn't have been harboring a fugitive. Are they?
I'm not sure the absence of charges is the criteria that we use.
Well, Judge, what this is forcing me to do to address that is to go outside the record, which is not what we're supposed to do, to say he wasn't running. According to everything we know, the police knew where he was. So he wasn't a fugitive, so they weren't harboring a fugitive. I don't know what were the accessories after the fact. I don't know. Is there something they want to confess to? I'm happy to hear it, but I don't know that anywhere within the four corners of the complaint there's a suggestion that the Laundries were under investigation for a crime or that they had committed a crime. So, first of all, I think we shouldn't even be considering this as an affirmative defense. Secondly, you can't look at the complaint and determine was there an investigation into them and what were the crimes. So I don't think the Fifth Amendment applies. If we turn to the First Amendment, I will tell you I strongly disagree with counsel's assertion that it applies in all instances. The defendants rely on Woolley versus Maynard for the proposition that they have a constitutional right to say nothing. But Woolley says that the right of freedom of thought protected by the First Amendment against state action includes both the right to speak freely and the right to refrain from speaking at all. And we're not talking about state action in this case. The defendant says we're asking the court to force the defendants essentially to say something. That's not what we're doing. We're seeking damages for their conduct. More importantly, the First Amendment does...
Mr. Riley, though, I want to direct you back to paragraph 30 of your complaint, where you say that the defendants were keeping the whereabouts of Brian Laundrie secret, and it is believed were making arrangements for him to leave the country. So that's something that the plaintiffs themselves injected into the case. So that's the basis of my question, is now that you've put that fact into the four corners of the complaint, isn't that the basis for me to consider, without having to need a affirmative defense filed, if you will, the constitutional rights of the Laundries?
Judge, what's the crime committed there? What's the crime if they are making efforts to try to remove him from the country? He's not been charged with anything. He's not a fugitive. There's not, that itself does not suggest that they were committing a crime. There has to be an underlying basis. If the complaint said there was a warrant out for Brian Laundrie's arrest and the Laundries were moving money around to try to move him out of the country, I agree with you wholeheartedly that you could arguably consider a Fifth Amendment argument in this case. But there's nothing in there to indicate that there was any criminal conduct on the part of the defendant. There's a statement that says they were moving money around to try to get him out of the country. Is that unlawful as it's pled in this complaint? No. It's not.
Okay.
Going back to the First Amendment issue, Your Honor, it doesn't set forth an all-encompassing right to remain silent. Only where through state action they are being asked to espouse a religious, political, or ideological cause which they do not support do they have that right. And I will cite to you from one of the cases in my brief, my motion, the Overbay case, which says, freedom of speech includes both the right to speak freely and the right to refrain from speaking at all. At its heart, the right to refrain from speaking is concerned for preventing government from compelling individuals to mouth support for views they find objectionable, or mandating speech that a speaker would not otherwise make. In other words, the court continued, the right to refrain from speaking limits the government's ability to sanction or override a private individual's preference for not making certain speech. Not all speech, certain speech. So let's look at Overbay.
Mr. Riley, you have 5 minutes left, sir.
Thank you, Your Honor. Are the Laundries suggesting that we're seeking to compel them to mouth support for a view they find objectionable? Do they find it objectionable to tell a grieving family where their daughter's body is located and that that she's no longer alive? Do they believe that they would have a personal individual preference for not making a statement that they knew where the body was located? That's ludicrous. The First Amendment does not apply in this particular circumstance. We pointed out that they contacted counsel to show a course of conduct and to support our proposition that they knew that Gabby was dead and that they knew where her body was located as of August 28th. They immediately contacted an attorney.
I get back to where's the duty, and certainly there's no legal prohibition on calling a lawyer.
I'm not, Judge, I'm not going there. I'm saying that's support for our position that they knew. That's circumstantial evidence, in my view, that's why it's in the complaint, goes to show that at that point in time they knew. I'm not being critical of them retaining an attorney. I'm not suggesting they shouldn't have. I like the fact that they retained Attorney Bertolini, and Attorney Bertolini said what he said on September 14th of 2021. So we're not saying they shouldn't have hired an attorney. We're not saying hold it against them for hiring an attorney. I'm simply saying they hired one immediately after getting a phone call from their son, who then returned home without Gabby. Circumstantial evidence to show that they knew.
I thought they had more than that, though.
That's the only reason that I raised that issue about them hiring a lawyer. Your Honor, unless you have any other questions, I believe I've covered everything I wanted to cover.
Thank you very much.
Thank you.
Mr. Luca,
Interesting.
I'll give you 2 minutes for any brief reply, but let's keep it to 2 minutes.
I feel like this
Yes,
attorney
thank you,
did
Your
a
Honor.
better job at communicating.
Your Honor, one thing I would point you to with regard to
the
that
guy.
City of Mineola case, Your Honor, there is a second DCA case, Crenshaw versus Sarasota County Public Hospital Board. I think it's cited in both my motion and the plaintiff's brief. And in that case, Your Honor, that case also involved a dead body, a stillborn child. And basically what happened is after the child was born, deceased, somebody within the hospital mutilated the child. It ended up going down a laundry chute. And in that case, Your Honor, importantly, the court noted that obviously if the mother had witnessed all of those terrible things that happened to the child, that might be one thing. But the court noted that the physically injured party should be directly involved in the event causing the original injury. If such a person sees it, hears it, or arrives on the scene while the injured party is still there, then that person is likely involved. And then they go on to say, here, appellant did not allege that she saw the mutilated body or that she was involved in the event, except for the birth of the stillborn child in any way. So, and Your Honor, that Stedman case was cited in Mineola, and in Mineola, the fifth DCA said that to the extent that Stedman conflicts, they're not going to follow Stedman. But Stedman would control here because it is a second DCA case. And lastly, Your Honor, I didn't raise this, get time to raise this initially, but I would point Your Honor to another important case, which is MM versus MPS. It's a third DCA case from 1989, again cited in the papers. And although not perfectly analogous, that case is instructive because it involves the parents suing the defendant for something that was done to their daughter. And in that case, the defendant told the parents that he had sexually abused their daughter, but obviously the parents were not present for the abuse. In that case, the court found that the appellants were not present when the alleged mistreatment of their daughter took place and may not claim emotional distress for her injurious or offensive treatment. Now, the plaintiffs countered that the disclosure of the treatment of their daughter was what caused their emotional distress. And the court said, after reviewing the law, we are unable to conclude that learning the awful truth from the defendant afforded appellants grounds for recovery for their own distress.
That's wild.
And the court said, if courts were to allow relatives of tort victims compensation for the distress they suffer when they receive bad news about family members, when there is no attendant intentional or reckless conduct directed toward them, an avalanche of litigation would ensue. Compensation is available for actual harm to the victim. Only in carefully prescribed circumstances is compensation permitted for relatives who suffer emotional distress. It is not lack of compassion, but necessity that restricts relief to the immediate victim. And Your Honor, in this case, I would just submit to Your Honor that allowing a cause of action like this to proceed would create an avalanche of litigation that the tort was never intended to cover. Thank you, Your Honor.
Thank you both for your arguments. I will do my best to get a written order out within 2 weeks of today. Anything else in
That's
this
it? Oh, we're
first
not
case
gonna-
before we recess the first case?
No, Your Honor. No, thank you, Your Honor. May I be excused?
Yes, sir.
I don't represent any parties in the second case, so.
That's fine. While he is,
Yeah, he's just
Mr.
out.
Luca is cleaning up, is there anybody that's going to be here In the second case, which is Nicole Schmidt as administrator of the estate of Gabrielle Verona Petito versus Barry F. Spivey as curator of the estate of Brian Laundrie, case number 2022 CA 2115SC.
Your Honor, Patrick Riley on behalf of Nicole Schmidt as personal representative of the estate of Gabrielle Petito.
Okay. And has anyone appeared for the respondent?
No one, to my knowledge, has appeared. As Your Honor knows, Attorney Spivey, there was an order entered at the request of Attorney Spivey that because it was the Laundrie family who filed the objection to the claim that was made against Brian Laundrie's estate, they should defend the action. An order was entered appointing them ad litem to defend the action. It's been more than 20 days since I served the complaint on Mr. Spivey, but out of an abundance of caution, I'm giving the Laundries a period of time to respond, although the information that I have is that they are not going to and that a default will be entered.
Okay. Well, Deputy Velez, if you could sound the halls for Barry Spivey as curator.
I don't know what the second case is. Barry Spivey's, I think, an attorney. And this other guy dipped out. This other guy was like, fuck that, I got paid, I'm out of here.
Okay, thank you. The court deputy advises no response to the sounding of the halls. Okay, well, let's. What's your intentions then in this case, Mr. Riley?
Your Honor, I've never had a situation where quite like this. So I don't think I'm obligated to give the Laundries 20 days from the time they were appointed as administrators ad litem to defend the action. But to avoid any future issues, I'm going to give them 20 days, and then I'm going to file for a clerk's default.
Okay.
What?
And you requested a jury trial in your complaint, I believe?
I did.
Okay, so we'll then have to have a jury trial on the issue.
Yes, Your Honor, we would be prepared to proceed to trial on that matter quickly.
Okay, well, I mean, it's a little premature relative to no default, but
Damn.
Are you looking towards November, December, or what was your trial?
Without my trial calendar here, Your Honor, I'm not certain, but probably more likely sometime in early 2023.
Okay. Well, I mean, hopefully for case managements in the future, you can bring your trial calendar.
I apologize.
Okay. Well, we'll wait and see whether you obtain a default or if someone appears. Obviously, if someone appears, I want you all to go ahead and do the case management order and get deadlines set, and so that we'll get the case rolling. If you end up having a default, then we can set a trial. I don't think we necessarily need another case management. You know, we've got a November 14th, December 12th, then we'll, in the new year.
Your Honor, I can look at my calendar now.
Yeah. Well, I mean, I can't set a trial right this second because there's no default.
True. Okay.
But the reality is, because you requested a jury trial, we're going to have to impanel a jury on it, assuming that you're going to proceed with the case. I mean, obviously, if you decide not to proceed with the case, then you don't need to have it. But we'll call a jury, and we'll go from there.
Very well.
It's just, I'm trying to figure out, with all the other trials going on here and which judges are going to be here when, just need to start planning these things out.
I hope that doesn't mean what I think it means, but for next year.
Oh, I have no idea which judge is going to be here in 2023. That's the chief judge's prerogative.
Understood.
Yeah. So I will not reset a case management if Mr. Spivey or an administrator shows up. I'd ask that you go ahead and do a case management order and send it in, a report. If it is a default, send my judicial assistant word that the default has been entered and a couple of dates on our trial calendar where you're looking for the trial to be had, and then we'll go from there. If assuming that there is a default, how many days of trial are you anticipating?
1 to 2 at the most. The witness list will be short.
I suspect jury selection will take us a little bit of time.
Well, that's why I was saying 1 to 2, because I think I could try the case in a day.
Okay. Anything else in the second case, Mr. Riley?
No, Your Honor, thank you.
No? Okay. With that, we're going to be adjourned for the afternoon. Thank you all very much for being here, and have a good afternoon.
Thank you, Your Honor. You as well.
I guess that's it. It seemed like the judge was pretty, I guess, kind of fair. He was asking both parties questions to try to kind of challenge their points. And so what they were saying here, too, is that, let me see, they said 2 weeks, right? Brian Enton says, arguments finished. Judge says he will try to make a written decision about whether the case can continue within 2 weeks. I thought he was going to do it right on the spot. I didn't know we are going to have to wait 2 weeks. And also the whole thing of, let me look at the article here.
Within the hospital, mutilated the child. It ended up.
They're claiming, I thought there was going to be kind of like, I mean, I guess this is not about evidence. We don't know if it's moving forward or not. Maybe it will. I don't know. It says they're saying that the parents knew about this death on or about August 28th. Wish I had a better timeline. It's been a while since I've looked at all this stuff. Oh yeah, because August 27th, there was that fight at the Wyoming restaurant, and the witnesses came forward. That was August 27th. So and that was the last time. Well, it says here, let me see. Oh, okay, yeah. Let me show you what I'm looking at. I'm kind of warning what evidence are they just, I guess they don't need much. He said it's circumstantial what they believe. But if you guys remember, there was that whole thing with the fight at the Wyoming restaurant. Oh yeah, Nina Seeley and Angelo took to her Instagram saying she witnessed Gabby Petito and Brian get into an explosive argument at the Mary Piglet restaurant in Jackson Hole, Wyoming. And I remember when that thing first came out, we thought it was like maybe she was making it up, or some people thought it was fake, but it turned out to be legit. And she said here that she said Laundrie was screaming at the hostess, who was losing his mind, and Petito was in tears and apologizing. It looked as though they were almost getting kicked out. Angelo told ABC News it wasn't necessarily between them. It was more so Gabby abruptly leaving the restaurant crying, and Brian was just evidently really upset, pissed off, I would say. Gabby was upset. He was angry, and he was just very temperamental towards the restaurant staff. Angelo said Laundrie was very visibly angry and Petito distraught. This is the last known sighting of the couple together. So that was August 27th. And they believe here, they're alleging in the lawsuit that on or about August 28th is when Brian told his parents that he killed her. And then on September 2nd, they contact Steve Bertolino to get the attorney. Let me see the other quick timeline here. So August 28th, and then September 1st. Remember that whole thing? I remember this whole crazy thing where they, the text message that supposedly was from Gabby's phone, but they don't believe it was Gabby, and she was deceased at that time anyway. But the whole thing is, can you help Stan? A lot of people thought it was the Eminem song. They thought it was this, thought it was that. But it said it wasn't normal behavior. And then this guy shows up back to Northport in the van by himself. And September 11th, that was kind of weird too, the time gap. But September 11th, between September 1st and September 11th, she was reported missing. And September 15th, he was named a person of interest. And that took a really long time to happen. I'm surprised it even happened then. Northport press conference, Laundrie sister speaks. Man, this is kind of like taking me back or reminding me about all this stuff. That whole family vacay where they went to, what's that place called? Soto something? Fort DeSoto? Sus as hell. Oh, and this whole thing too, the double homicide, which there was an update with that. They found out who the guy was. For people that don't know about that, I covered that on the channel. I think I covered it, right? I don't know. I don't remember if I did or not. Maybe I didn't. I don't know. But they, and Sean Paul reached out to me and he was just like, thanks for the support and stuff like that. But the guy had killed himself. A lot of people thought that Brian was linked to this double homicide case. For sure. Like, people were announcing that shit as a fact. I was like, damn. Brian Laundrie reported missing. Dual searches. And that was it. So I don't know. Let me see what else is on this article. I really don't know if there's enough to go forward or not. I mean, I think it's possible. But then if they do go forward, are they going to win? Speaking to WFLA in March, Pat Riley, the Florida attorney representing Petito and Schmidt in a civil suit, suggested their evidence would be revealed as their lawsuit moves forward. So maybe once they get into it, maybe they'll bring out the evidence. If they have more, they'll have to wait and see. Riley told WFLA that JB Bruno, when asked about evidence, if we didn't believe it was true, we wouldn't have put them in the complaint. And they seem really confident too when they're talking about that they knew about this murder and that they tried to help him leave the country. The statement too, let me show you that real quick. So the statement they were referring to was September 14th. So this is after Gabby's death. This is from the Bertolino, Ms. Petito's statement from counsel of Laundrie family. This is understandably an extremely difficult time for both Petito family and the Laundrie family. It was our understanding that a search has been organized for Ms. Petito in or near Grand Teton, I can pronounce it now properly, National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Ms. Petito is successful and that Ms. Petito is reunited with her family. An advice of the counsel of the Laundrie family is remaining in the background at this juncture and will not further comment. So they're saying like this is jacked up because they're claiming these people knew where the body was. They knew she was dead. They knew the entire time because Gabby was found. So Gabby was found on 9/19/2021. All right. So family's desperate searching. They want to know where, making all these pleas and stuff. And they released this statement talking about we understand how difficult it is. We understand about the search going on. We hope that she's found. We're not saying shit else. They're claiming they knew. And then a couple of days later, Gabby Petito's found. Well, actually, so this was the 14th. On the 17th, Brian was reported missing, and then Gabby's found 9/19. I have some old notes, but there were some people that did like a really good job with the timelines. Yeah. Mars Life said, nobody will ever convince me the evidence in connection with double homicide is not true. So you believe it is true. Sean Paul is amazing. He's a good guy. Yeah. Really good guy. Lexa said I was over here having true crime withdrawals. Yeah, we're gonna get back into that. I was kind of looking at another case. I think later tonight and tomorrow I'm gonna start collecting notes to put out a video. And I heard about all that drama too with James Terry and Dylan Rounds. I listened to the audio over the weekend. That was pretty nuts. But I guess that's it. I guess we'll have to wait and see if this goes forward. If it goes forward, it can be really interesting. Maybe that could be a trial that we cover. But it's not going to be long. Didn't he say that he thinks he could do it in one day? And then the other thing too, I forgot who. I took a little screenshot somewhere. Somebody said that the second case is about the property that they haven't gotten back. There's still some property, I think, of Gabby's that they haven't gotten back from the Laundries. And so maybe that's what that has to do with it. James found out the boy. No, hoax. I called him on the. You know what that whole situation reminded me of with James Terry? I was covering, I don't know, for the people that have been here on the channel for a long time, I was covering Noemi Boulevard. That's the girl that went missing from South Florida. Mormon, which I didn't know. Hoax. The whole thing with this guy, he's Mormon too, right? Or his family's Mormon. I'm like, oh shit, the Mormons again. And so the thing with this girl, that's the case that I really deep dived on, whatever. And it came out to be that she was either like bi or gay or whatever. And the reason that was relevant is because I had heard that like her family wasn't accepting of that. And the more and more I dug into that, the more and more confirmation that I got from a lot of different sources, even people that I can't say because I promised I wouldn't say. And some people got really pissed off at me. Oh, you know, the Mormons were calling me. Some people in Utah, her friends from the church, they called me. They wanted to talk. We spoke for like an hour. They all wanted to know how I knew. And then I spoke to somebody else that I can't say that confirmed it as well. So, I mean, I don't know. That could have been part of it, that maybe just they weren't accepting of that. You know, shit happens, man. But yeah, some people were really upset about that. People didn't like that. So, but I mean, I saw the way he was talking to the family too. I was like, I don't know that I would do that myself. But I haven't followed the story, so I don't know. I know that they hired him, and I think he was paid in full, and he wanted to keep working with them. And I guess they felt like he was doing conspiracy theories or something. I want to go to Utah someday. I want to see the Mormons in person. I don't know if they're going to recruit me, but I want to see the Mormons. That PI is crazy. Anytime I've ever brought him on, people get pissed. People get really, really triggered. Why you bring him on? Why? Why? It's like when I bring on Molly. Really pissed. But he's found missing people. Like want me to open the lines? If I open the lines, I can do it for like 30 minutes because then I got to go pick up the baby. Want me to open the lines? Yeah, I'll open up the lines. We could do 3-minute calls. Well, it depends. If nobody calls, just one person, then we'll just take the one call. Call it a day. Let's see. Been so long, I don't even know how to open this shit up. Yeah, he found Gloria Alvarado. I think he's good at what he does, but he's just very rough. He's just really unfiltered. He's not going to hold back. He's not into like, whatever the safe talk of society these days. You have to, watch what you say, be careful what you say and how you say it, or they cancel you and shut you down. Okay, let me call in here real quick. I already see Cheeks. Been a while, Cheeks. Let's see, hold on. Give me 1 second. Let me just dial in here. Could just call Mickey directly. It's true. Right? Just call her. Let's see. Okay.
and can manage your callers from the call-in studio web interface.
Uh-oh, Shelly. Shelly says, I was born and raised by LDS. You know, when I was covering that story and I was talking about Naomi, which I really try to be respectful. I think they're really nice people. They've been nice to me. I mean, they kind of stopped talking to me after that whole thing, but somebody came on Discord and they were really upset about the things that I said. And it was an LDS person. All right. 407. I have two 407, so I don't know who this one is right now.
It's Cheeks.
Cheeks, what's up? How you doing?
Somebody's
trying to throw me off.
Mel.
What's up?
No, I didn't call twice to be like, I need him to figure it out. No, I didn't do that. But
It's a psyop trying to set me up.
I'm telling you. Listen, okay. So, first of all, so glad that you're back covering true crime. You already know.
We're back.
I'm a true crime head.
Time to get back into it, yeah.
Yes, the Johnny Depp thing, you remember at first I told you I really wasn't rocking with it, but then it was
Right.
you, and then you suckered me into it, then we was all in it, and then there it was. Okay, so boom.
appreciate
Glad that it's done and over.
I am kind of too, to be
Team
honest with
Johnny
you.
got it.
Yeah. It could
So,
be
listen,
starting again,
first
though. They're
things
doing another
first.
trial, but I don't think it's televised. They're doing something else. They're doing the...
So listen.
Yeah. Go ahead.
Go ahead.
No, go ahead.
Go ahead.
It's your time. Go ahead.
Okay, so first thing first, I'm gonna need you to do like a mini update of multiple cases because now you already know that I've been holding out for Maricela. I've been waiting on that. You remember? I remember your shout out. I was like, yo, I think they were caught. You were like, no, and then the next day you was like, Cheeks, you was kind of right, girl. You was kind of right. So I'm gonna need an update on that one. I did not know that they found the guy who killed the lesbian couple out there. I had no idea. When did they find that out?
Very recently, because it was, I don't know when. It was super recent because Sean Paul had messaged me, I think, on Facebook. He was telling me he was really happy. He was like celebrating. He's just happy this guy's caught, but even though the guy killed himself.
Oh, yeah, of course.
And it was a coworker at McDonald's that worked with Crystal. It was Crystal? Yeah, Crystal.
Oh my God! Okay,
some deranged
please,
motherfucker.
I need a motion update. You gotta
we
do a
gotta do it.
multi-case update.
You're right.
I'm telling you. I'm telling you. I loved everything that we were doing in between. I feel like you need to make the interrogation watch. I think that's something that we need to kind of do like once a month or something like that.
Yes, I like the ideas. That's
that was
true.
really good.
People love that. Yeah.
Because remember, you were supposed to bring up, what was his name? Ryan White? I can't remember. The investigator. I don't want to say anything about the interrogation, but I did send you some information about it on Discord. I was really hoping that we were going to get to that interrogation, but we didn't get a chance to. But nonetheless, going back to the original thing, this Petito thing, I'm really hoping, I feel like everybody has said the same thing that I was thinking. I really feel like the judge is trying to be fair.
Right.
I'm kind of on the fence on whether or not this is going to go to trial. Remember when I told you when this first happened and I gave you the case where the father took the son to court over a civil matter because they did suspect that he had actually killed his mother? They won that case, which caused for the police department to reinvestigate, and they did take the son back to trial, but I believe the jury either deadlocked or they declared it a mistrial, and unfortunately the son was not found guilty of murdering his mother. But again, I still stick by this. I do not believe that this is a situation where the Petitos want monetary. They don't. I think they just want the Laundries to finally be held accountable for the information that they knew.
Right.
I think this is really what it is, to bring light to it, because they've been ducking and dodging. We saw how they were ducking and dodging out of that house, ducking and dodging everywhere they went when people were out there. I think this is what it is. And I think it's also going to bring that police department underneath the scope, because wouldn't this lead to an internal investigation for that police department to be like, how did you guys drop the ball this bad that when these people took it upon themselves to file a civil suit, they won the civil suit, but you guys are saying things to that effect? And I still don't understand how the Laundries, I'm trying to keep up with names, how the Laundries could not be held accountable, because like I told you before, when we were watching this shit, there is no way in hell you gonna leave as a couple, then come back alone in this girl's van,
bruh.
Okay,
Makes no sense.
And not be suspicious. I'm telling you that. My dad would be like, listen, my dad would be like, hey nigga, what you do with my daughter? I'm gonna just go ahead and keep it 100. My dad would not play that shit. My dad would be like, listen, I don't know what the fuck you did, but you came back here in her property. So I'm gonna need some motherfucking answers. And I'm gonna be knocking on your door. And I'm gonna call the cops because it's some fishy shit. I don't understand how people don't see this as outrageous behavior. You were pretty much connected to these people by marriage. Y'all weren't going to be indoctrinated in marriage. You blocked the family. Y'all don't report that the girl was missing. Your son came home on her property. You go on vacation. Ain't no way in hell. I don't see how people don't see these actions as outrageous. The fact that they're citing all these cases, I see a lot of people are confused. They're citing these cases because these are supportive cases in regards to what can be deemed as outrageous, like the situation of the debtor calling the complainant's mom, talking about, oh, I'm from the hospital, your kids were in an accident, and that man went calling all those hospitals in Cali and shit looking for his kids. That is outrageous. You cause unnecessary stress. My emotions are running high. I don't know what to think. I can't think straight. I don't understand how them doing what they did, allowing their son to come home in that girl's property, not just any random girl, his fiance. You send them off. This motherfucker comes home without the girl in her thing. Y'all done cleaned out her damn storage locker. You go on vacation like this is normal. You block the family. And y'all don't say anything until you get a lawyer and then you put the statement out. I do feel like they knew something, and I don't understand how they can say that essentially by law. I'm like, all these damn crime cases that I've watched where a friend knows something that a friend did, and then you know what, I'm being held responsible for knowing about a crime and literally not saying anything. I don't understand how they weren't charged with something like that. That's why I said we need Terry on the phone. Like, Terry, how is some of this stuff possible? Because I don't know. People get charged with shit like that every day, B. You know your friend killed somebody.
But maybe it's about what they can prove.
Their investigation.
Maybe it's about not having enough evidence. Maybe it's what it is. But it's enough for probably a lawsuit, though. But maybe, and like I saw what Hoax is saying, morally it's wrong, but is it legally wrong? It depends if they knew.
It's so confusing. Like, it's just really confusing because, like I said, you see shit about people being held responsible for knowing about a crime, but then not going to the cops to speak on the knowledge of the crime. Is this not the same situation? You can't sit here and say that it's parent-child privilege. First of all, I don't even know if that's a thing. But like I said in the comments, Brian was a grown-ass man. This man was about to be married. He was about to start his own family. So what is this BS that the lawyers talk? Like, no. The Laundries need to be held accountable for something. And I just don't understand how you allow your child, as a parent, this it's like the Laundries and the Crumblies. I'm grouping them together. The signs were all there. You know what I mean? The signs were there. Your son is out here wilding at the age of 13, 14, 15, however old he is. He literally is telling you that he needs help. And instead of actually doing the right thing by trying to seek medical attention for your son, which has been brought up to you by the school, okay, you go out and go buy him a gun.
And take him shooting.
When the school tells you that y'all need...
And take him shooting.
And then when the school tells y'all need to come and pick him up, y'all like, nah, we'll pick him up at the end of the day. Only to find out that the end of the day was literally at 10 o'clock in the morning because your son did what he did. I have empathy for Ethan now because I did not realize nobody knew all that shit was going on until the shit went to court. And then that's when we found out. But I'm feeling like the Laundries and the Crumblies must have picked up the same fucking book from Barnes and Noble on the dummy guides of bad fucking parenting because I don't understand how your grown-ass son comes home. He leaves home with his fiance in her shit. Then he come home with her shit, but she not there. You gonna tell me that y'all sat in that house for 2 days, awkwardly silent, and not being like, so what's up? Where's Gabby? Like, I don't understand it. I don't understand it. This damn lawyer in this ill-fitness suit and that crooked ass fucking tie, sick of his ass. He's like, what's his name? Fucking Rottenborn. I'm tired of them two motherfuckers. Tired of those two. And I'm on the fence because I want some justice for the Petitos. And I like the judge that he really is truly trying to ask the right questions to make sure that he's making the right decision. And everybody wants him to rule in favor for the Petitos, but I'm really hoping that he's choosing his ruling based on what's presented. But at the same time, it's just kind of like, I just don't understand how we can't take them to court over at least knowing. You know what I mean? I just don't understand how you don't know. This is know that their man is cheating by a change of activity in his day-to-day routine. How the hell do y'all not know that your son has possibly done something really, really, really suspicious coming home in this girl's shit? What reason did he give that Gabby didn't come? What reason? These are the things that they need to explain. If y'all are clean, come to court. Like I said, because if somebody's going to blame me for some shit, I'm in court every day. I'm going to speak my truth. Sorry, I ain't have shit to do with this. I don't know what they're talking about. I'm going to speak what I know is the truth because that's what I live. But the fact that y'all are ducking and dodging and you got all these lawyers speaking to you, it doesn't look good. It does look sus. And your actions have also been such since day one this shit started. I just don't understand. There's something going on in that police department. I don't know who the hell is sucking who off. It's too much. It's too much. I don't know if Rebecca's out there selling some booty or getting some booty up, or if her husband is pimping her out to keep her son safe, whatever. I don't give a damn. I really do hope this does go to trial so we can see the evidence. I think a lot of people were asking why there isn't evidence. Yeah, I think they were asking. I think in the preliminary, you're not obligated to show evidence unless it goes to trial, because this was just to see if we were going to take this to trial, right?
Mm-hmm. Yeah, this is just to see if we're going to, if the judge is going to move it forward to trial.
Right. And I think a lot of people, you had a lot of people in the chat asking, where's the evidence? Where's the evidence? And I said, I don't think they're obligated to show their evidence, until we know for a fact that this is actually going to go to trial. You're not going to be obligated to show your hand unless, we're actually going.
That's exactly what it is. It would be showing their hand ahead of time.
Okay, so that's what that is.
I think, it's probably better to wait. But yeah.
Yeah.
I'm curious to see.
Gabby's mom, I'm praying for her because that's no disrespect, no shade, no tea, but that woman seriously looks ill. Like, she has been crying every single day since this shit has started. You and I are both parents. We're parents of little girls. There's a special connection with your girls. Right. To hear some shit like this and have to, these people don't want to look these people in the face. That's why they pussy asses didn't show at the fucking court. Look at how that mom looks. She looks stressed out. And I cannot imagine. My daughter is visiting family for the summer right now, and not for nothing, I am sick with my child. And this is stuff that we do every single year because I'm like, if something happens to my daughter and I'm not around, how is that going to make me feel? And it's not even like on no negative shit. This is just shit that you think of as a parent. And to see her mom just makes me livid. And I really do hope that these punk son of a bitches end up bringing their asses to court so they can look them people in the face. Read them a victim impact statement. Your bullshit ass actions have affected my life since the day this shit has happened and will continue to do so until the day that I am 6 feet under and I can join my daughter in the afterlife. Y'all are punks, and I'm about to cross over this shit and whoop y'all asses. I swear to God, somebody should whoop somebody's ass in court.
Cheeks, thank you so much for the call. People love you. The chat loves you. Yeah, I was calling you. No, you're good. You're good. Everybody loves you. I was calling you Camille 2.0 because you were going in.
Listen, you already know I stand for Camille. Don't get me started on my girl Camille. I told y'all she was going to secure the bag and get that damn partner's position, and my girl did that. Period. Just like that. I'm telling you. But listen, I'm going to let you go. First of all, I'm so glad that you're back. So
appreciate it. Yeah, let's get back into it. Back into crime.
Yep. I'm telling you. Let's get back to work, Belle. Get back to work. That's what I'm talking about.
Thanks, Cheeks. I appreciate it. All right. Thank you.
All right. Bye.
Bye. Nice to hear her voice again. Motivation. Let me get these two other calls because they've been holding for a while. But I was also thinking too, I'm not going to say too much. I'm going to try to remember to say it after. I was thinking, listening to Cheeks, but like that case was crazy too. I thought they said that like there was a case that somebody was like raped, a child was raped or something like that. And so the person went and tried to sue them for like emotional distress, but they said no or whatever, because I guess that's only reserved for the actual victim. I think that's the case that the Bertolino's side, or I mean Laundrie side, try to make And I mean, I guess that makes sense. It's kind of jacked up, fucked up. I don't know. Because he was saying then there'll be a bunch. So they're trying to say, I think the Laundrie family's attorney was trying to say that, like, so they're trying to say that they were already, the Laundrie family saying that they were already grieving, and so they couldn't have really added more to it. I don't know, but that was kind of crazy to hear. Let me take the other 407. 407, how you doing? Where you calling from?
Hey, it's Shannon. True Crime with Shannon out of Florida.
Hey, welcome.
And
Oh, in Florida. Nice. Are you in North Florida or South Florida? Where you at?
I'm in Orlando area.
Oh, Orlando. Nice.
So,
Nice.
yeah. I've been missing you, Mel, because I've been covering some stuff.
Thank
and I'm like,
you.
man, what's up with you?
Yeah, I took a
I know. I was like,
long break, but I'm back now.
Well, hey,
yeah.
sometimes you need a break.
Yeah.
But I've been following the rounds thing, but I just want to say about Gabby, because I've been following that too, for my channel and stuff. And let me tell you, I think, they have a case, because here's the thing. I mean, it's like you said, the experts are saying it's in the middle, because, it's one of those things that almost sits on the line of moral, but here's the thing. They made a statement through their Bertolino, who, I never liked him from the get-go, but I know I ain't the only one. But they made a statement saying, that's the whole thing right there, that we hope she's found and all that. That's where, that's where I think that they're going to be able to get a trial, because I really hope that we're going to get that opportunity, because I don't know if they'll win, because but civil trials I know are like, you have to have less to go forward. So I think that this judge grants them that trial, and that way, and then the jury can decide if there's really anything, because I don't even think that the family wants money. I think they want the truth out. It's sort of like Johnny Depp, he don't care about the money. They just want people to know the truth. And I think that they know they want the truth to be known, not only about Brian, but his family. They're a bunch of liars, and they just are awful people. I mean, how can you treat, the family like that? She was going to be your daughter-in-law. I mean, how could you treat them like that? I mean, you highly disconnect from them. You don't talk to them. She disconnected, didn't answer their calls. She blocked their numbers, blocked her on Facebook. Roberta, I mean, to me, there's just so much stuff going on that family is just truly messed up. I mean, even the judge said it, that they have a right to remain silent. They did remain silent. They made it.
Well, that's exactly what I was. Yeah, that's the point. That's the point they were making. You're right. Like, because they were saying, it's their amendment right to remain silent, but then they're like, but you made a statement on it. So, and I don't know how that works. Like, so I mean, can you make a statement and then still continue to remain silent, or does that
either? Yeah, I don't
take that away? Let's see if I can ask Terry.
I don't know, but also the question is, like, Terry needs to answer, like, okay, so, and I don't think and I think that he was right, and the judge was saying there's no real protections that I'm aware of, that if someone tells you, oh, hey, like this, your kid, say, oh, I killed my girlfriend or my boyfriend, I don't think as a mom or dad, regardless of if you don't want them to get in trouble, because I know as a mom and dad you want to protect them, but I don't think you have that kind of protection. I think you are still kind of an accessory. So I think it's like, and even spouses have gotten in trouble for that. So I think murder, killing somebody is a whole different ballgame. So, I mean, I'm not so sure that there's any protections, because they were never really charged with anything, but
with the spouse
FBI,
thing, though, with the spouse thing,
I don't know. The spouse,
it's kind of weird, because like the Maricela Botello case, and I know Cheeks out there is probably still listening, but like these two ladies and the guy, I mean, it's kind of complicated, but like the two ladies are married that are involved in the killing, and so they bonded out together, and they were able to live together because they're married and stuff. And so I don't know if there's like certain protections, because normally I would think they wouldn't have the same address, but I guess they're allowed to talk. And to me, it's like, well, they have time to get their story straight. But I guess because they're married, they're allowed to do that, I guess. I don't know exactly. I'd have to ask Terry on that one, too.
By state or not. That's a good question for Terry to answer. Like, I mean, is it by state, or is it like completely, because I have to research that too, but I know there's no protections for like mom and kid, all that, dad and kid, like, and if your friend told you, like he said, when he goes outside and commits a crime, he don't have to say anything. I'm like, yeah, but if you told your friend you killed somebody, that's attorney. I'm like, your friend could be an accessory just because he didn't go tell on you. It's like, your friend now gets involved. So it's like, if you knew, which I think that, I mean, how could they not know? He didn't come home with all that, and they, and they even proved it. The FBI said that he was the one texting the family. So I think that mom and dad knew, And I think that, I don't know what they knew, but they knew that she was gone. And I think that, if that judge believes it enough, and I think we're going to get a trial, and I really hope we do. I don't know if we'll get beyond, anything from that. But I think it'll be at least a good way to get some closure for this family and for all of us that have been following this whole case. I mean, this poor girl, she just wanted to go out and, live this life. And she was almost marrying, thank God, but she was almost marrying a psycho.
Mm-hmm.
Who knew? In his family, though, I still don't believe the sister didn't know something either.
That's just weird. The whole family trip. How could nobody ask during that family trip? It's just really hard for me to believe.
You never talked about Gabby. I'm like, yeah, you did.
And the sister said that they were close to Gabby, and that Gabby would call, I think, and like talk to the kids or spend time with the kids or whatever. So if they knew them like that, there's no way that this woman's. They're all on this family trip, and Gabby was supposed to be back with them, and she's not there, and they're not gonna have a discussion about this shit. Like, that's hard. I can't.
And then
believe
kids
that.
were going to ask. Nah, I'm sure, they all knew, and they told her to probably keep her mouth shut. And like I said, I don't know exactly what she was told, but nobody asked and no. They all asked about Gabby. That to me is that nobody believes that at all. And,
it's very possible that they knew, man. I mean, the family knew, because like even looking at the timeline, I think that September 6th through 8 is, I think, when they went on the family trip, registered to Camp Fort DeSoto. I think they left a day early, but they went there. I think they were supposed to go there between those dates. And then 14th is when the statement is put out. This was after the family trip when they're all sitting together and Gabby's not even there. She's already dead. What are they talking about on this trip? You know what I'm saying?
No, and there's no way.
Mm-hmm.
And they're supposed to be out, and then he comes home. Yeah, everything is super suspicious. And I think that, she was covered. She was like trying to, keep face and try to keep the media and all these people away from her house because, she had to answer her kids, and she had to tell them, oh, yeah, your uncle killed his girlfriend, killed the girl y'all liked. It was going to be, your aunt. And then, did he tell them that it was an accident? That's possible, but I think he told them that she was dead, period. I don't know how he said it, but how do you not ask your kid, he comes home, what happened to your girlfriend? Well, I don't know. You're going to be like, well, what happened to her? And he probably said, oh, it was an accident. He may have made it up. But see, they could have said that.
Right.
Why couldn't they say that? And, oh, we're trying to protect our son.
There's a live press conference? Hold on. People are saying live press conference? For what?
Is there?
Let me see. Okay, there's a press conference, people are saying.
Okay. Well, yeah, we need to keep up with this, though. I really hope we're going to get an answer before 2 weeks.
For sure. I hope before, too.
I know. I'm like, this is crazy. And y'all need to keep on the Dylan rounds, because keep his face out there, because I've been following, and the family doesn't want anybody to really go out there and try to do much, but they just want to keep his name out there because they finally got the law enforcement to move their butts. So that's super weird, too. So.
All right. Well, thank you so much for watching and for calling. I appreciate it.
Have a good one, Mel.
All right. Thanks.
Bye.
You too. Take care. If you guys could help me out with where this presser is, I'm going to take the next call. So right now I can't really see where it's at. If you're going to send it to me, let me know where you're sending it. I don't see a presser though. All right, I'm gonna take this call. You guys let me know, and once I get it, I'll play it for us. I can rewind it, but I don't see a presser yet. I'll keep looking. Let me take this other person. They've been holding for a long time. 972. How you doing? Where you calling from?
Hi. This is Eve Barlow, and I want to know why you are making mean videos about Amber Heard.
Oh yeah, who's this?
Lindsay.
Lindsay. Yo, I saw her page the other day. She's going off. She's she's going after Umbrella Guy, and a bunch of people are going after her, I guess.
He makes millions.
New YouTubers video dragging Amber Heard makes him up to $64,000 a month. Yeah. So what do you think about this whole thing? And thank you for calling. So a surprise call. It's nice to hear your voice.
I don't know. I guess it's just going to be like up to the judge's discretion, really. I mean, it could be like a coin toss to me. But one thing I feel like Brian's defense could argue would be like, well, we didn't mean for her to be found alive. We just said found. Because they did just say found. But I don't know. I mean, I see both sides.
Do you think the family knew? Like the mother and father? I mean, I don't even know how they would prove that. Yeah.
Yeah. Oh, I'm guessing they've talked to the FBI. Like they have. I'm sure the FBI told them this. Probably not knowing that they would go and do something like this, but I'm sure they got answers. They probably know all that. I don't think that they would go forward with just making it up. But yeah, I don't know. Oh, and the other thing is, like, since they already spoke, didn't that kind of waive their Fifth Amendment?
That's what I wonder. I want to ask Terry about that because they kept referring to that.
Yeah, they did speak, and I think that the fact that in Florida law that your lawyer is your agent, that's going to screw them. That will fuck them over.
Damn.
But yeah, anyways, I need to get better at my impressions.
It was kind of funny. I was a little afraid of where it was going because I'm like, fuck, I don't know how crazy they're going to get. But yeah, that's pretty. Oh, and they like released his picture too, the umbrella guy. Like these people are really going for this guy. Like, Jesus.
Yeah. I know.
Any trials you're looking forward to upcoming? I was still kind of browsing to see what we might do next.
Yeah, there's a few. I'll send you a text of some. But anyway, yeah, I'll let you go.
All right. Thanks, Lindsay. Bye.
All right. Bye.
Bye. Okay, 951, last caller. And then I want to play something for you guys. 951, how you doing? Where you calling from?
Pretty good. How about yourself, Mel?
Oh, shit. Junior! Bro, I was in Cali, man. I was just in Cali.
I know.
I want to come back.
I seen you, bro. You're a little MIA for a minute. I was like, where does this fool go? I thought he was in Florida still. And then I seen The Pursuit, and I was like, wait, somebody's telling you not to wear red over here, bro. He's in Cali, bro.
Bro, they're telling me not to wear red, not to wear blue. I got to see Skid Row. Skid Row's pretty bad, man. I mean, I didn't get to walk it. I kind of want to walk it too, but it's bad.
Yeah, it's like a total 180. You got like the whole High Life,
right?
Columbia fucking building over there or whatever, and then you got Skid Row. I think that's what there's Columbia building, right?
Yeah,
LA?
I saw that, the East Columbia building. Yeah, we drove by it. Yeah, I saw the East Columbia building. I got to see one of Johnny Depp's houses. Drove by that too. It's in I forgot where that's at, Hollywood Hills or something, or Hollywood. I don't know. Somewhere.
Some good R&R and shit, just chilling.
Yeah,
that's good.
Yeah, it was nice, man. Yeah, I had a blast. It's not as bad as I thought. I thought it was gonna be trashed and like the slums and shit everywhere. There's some pretty nice places.
Yeah. No, nowadays I feel like LA is cool to like visit, but like nowadays it's like the gems are on the outskirts of like SoCal, the outskirts of LA. I mean, you know what I'm saying?
Yeah.
But that's cool though. LA's chill. LA's chill. But damn, bro, I have my 2 cents to put in on this case. You know, I started following you off the Gabby case. That's how I started becoming. Oh yeah, hit that like for all y'all freaking listening.
Yeah, help me out with the like button
because Mel is back.
I'm back,
Mel's
man.
back and refreshed. So
no, disappeared for 2 weeks.
Let's get this homie up, man. Sure. But, all right, bro. I got a couple. Like, I first wonder has there been cases with this similarity, like meaning like just to be broad, like a couple, and then either guy or girl killed who and who, whatever, and then the other person went to the family. I'm trying to see if that lawyer of the Petito family knows, like, I know he's going to do his research because he was bringing up other instances and stuff, like saying, like, oh, hell no, judge, look at this case. That's why we're following whatever. But I think if they have something to go off of, it's going to help them. But if not, they're charting new territory, and that's when stuff can go, you know, their way or not. And also, bro, like, you know, we all know freaking Bertolino is their lawyer, the Laundrie family's lawyer. And real quick, you know, my mom always taught me, hey, if something happens, don't help, because that's aiding and abetting, and you'll fucking get hemmed up too. And I was like, for sure. So I know, you know, I know that gist, but I want to say if they can prove that they try to get this dude out the country, then that would for sure let it be known that he had told them. You know what I'm saying? Because why would you just want to get out the country? Like you obviously came back home alone, so your parents are probably gonna at least assume before you even tell them something like, oh shit, something's probably wrong. That's their child. You know, they knew how his vibe was, so they already knew what was up without even asking, because that's just parents' vibes. So they already have an upper hand right there. And maybe he did tell him, or maybe not. But if they can prove, that's the only thing I can think of. If they can prove that they were trying to get homie out of the country, why would you just do that for no blatant reason? And you know, I feel like Bertolino is talking to them as a lawyer, and it's a big double-edged sword with them on that end, because he's talking to them as a lawyer, and then he'll go, I'm guessing, hey bro, it's off the record type vibes, you know what I'm saying? Hey, you want to kind of do this and you want to maybe not do that. And I feel like that's why they're able to survive this long, because who knows, they might win and they might not have to get, you know, any repercussions and stuff. But if they lose, I feel like they went on so long because they had Bertolino to like maneuver them through every loop and hole, you know what I'm saying? But yeah, I don't know, man. I think that they for sure knew. They for sure knew. And what are you gonna do? You're gonna go continue your plans. You're gonna go to the little RV, little campground, and we're gonna chill and act like nothing's wrong. And when we're sitting around the campfire, we're gonna do diligently like discuss what happened, and we're gonna, you know, probably go from there and get the story straight, like, you know, a lot of people try to do. But yeah, Florida, that's where they're at right now, right? The judge, they're dude. Yeah. I feel like
Sarasota, I think.
Petito's lawyer and the judge, I feel like they're cracking heads a little bit. Like, bro, you gotta be chiller, bro. If you want to win, I feel like you can't go that hard. I know the Petito family's all frustrated and shit, but I could feel everyone that was listening and tuning in, and you can hear and feel the vibe of them clashing, like little mini clashes, you know. Mm-hmm. And I'm like, bro, that shit don't. After watching all this Amber Heard and all this stuff,
shit,
you
I'm surprised.
Pick up on this little,
and they brought up the Johnny Depp trial too. The judge did. I was like, oh shit.
Oh, did they?
Mm-hmm.
I came in late to the live.
I'm gonna play it when we get off. I'm gonna play the clip of that. But the judge was referencing like he was saying that one of the defamations that Amber Heard won, which was only one, was the whole thing where Johnny Depp's attorney, it was based off of Johnny Depp's attorney making a statement. So he was trying to say that just because an attorney makes a statement doesn't mean that you can't be, I guess, held accountable for it during like defamation or a civil case. So that was kind of interesting. And I'm like, damn, the judge watching Johnny Depp too. He was watching the case. I guess a lot of people were.
Everyone.
Obviously. Yeah.
Hell yeah. Everyone for sure. Mm-hmm. Yeah, I don't know. I think they knew though. At the end of the day, man, I think they knew, and I think they're just they have Bertolino right now, and he's gonna freaking wring out every drop from the towel he can to not get him hemmed up. But if it's out of his hands and the law is the law, and if they broke some type of, you know, shindig or whatever, then they're gonna get hemmed up for sure. For sure they are. And but it sucks though, because they're old people. You know what I'm saying? What are you gonna get out of it? They go to jail for a few freaking years before they die, if they do, you know, are found guilty or whatever and all that.
Did they go to jail?
Like,
or is it just I don't know.
My bad.
I think it's just money. I think it's just money. I think. Yeah.
Pain
Maybe it's
to them. That's probably jail to their ass too. Shit, money's fucking money's everything, and it's nothing at the same time. You know, fucking love and hate money, man. For sure. Yeah, for sure. Yeah, but I think they knew, bro. I think they knew, and it's gonna come out. And I think the judge, did he say like, oh yeah, we'll get a jury trial? If I wasn't mistaken, I was like, oh, let's go, bro. Let's go.
So he didn't say yes or no yet. But if he does say yes, which now it's going to take 2 weeks. He said he's going to do like a written statement, and in 2 weeks he's going to let everybody know. And that if it does, then it's going to go to a jury trial. I forget when, in next year, I think.
December, he said, huh?
Yeah. He said December?
Trying for early.
He said trying for early. Well, over here it says jury trial scheduled for August 2023. Long time.
Oh, shit. Damn. That's long for sure. Mm-hmm. But if it's up to the people, man, fucking Bertolino can only help them so much from there on. You know, it's going to be up to the jury after that. Right. And I think the dude said, nah, we just want it for 1 or 2 days. So that would suck to wait such a long time and have something so quick, you know? not that you want to ring it out and get every drop of it, but yeah, man, I just hope they get closure, dog. That's just fucked up. At the end of the day, when you just broadly look at it, it was just fucked up. It was just fucked up, big time.
I appreciate the call, man. Yeah, hope you've been doing good.
Yeah,
been taking care of yourself, man. I appreciate the support. People love when you call. I love when you call too, man. And
yeah, likewise, man.
Yeah, thanks.
Appreciate
We're gonna start getting warmed up, covering some more cases and shit. Just going back a little bit to some of the crime stuff. Yeah, and then also looking at what next trial we might cover.
Yeah, post up anything, bro. I'll be there, bro. Anything cool when you cover, dog.
Appreciate it,
bro.
man.
For sure.
All right,
I'll be in.
So we'll talk
Later.
Peace. Later.
See you, Mel.
Later. That's Junior. I always appreciate his calls. Good guy. I think that's it for the phone calls. Close the lines. Let me play this. So for the people that missed it, I had it somewhere. Let's see.
When we say them,
I would agree with that, Your Honor. Certainly, if you say words.
Johnny Depp just got found civilly liable for defamation by what his attorney said, right?
Johnny Depp. Again, Your Honor, I understand that in certain contexts, the statements of an attorney could potentially be, lead to something like defamation.
That is interesting. Very interesting.
I agree with you on that. I think really what we're talking about here, though, Your Honor, is a statement by an attorney that even in and of itself is certainly not defamation, and it is not outrageous.
My understanding of the statement, and correct me if I'm wrong, is the Laundries knew, and again, this is on a motion to dismiss, so I have to accept what is alleged as true. Not that it is true, but
So in that thing too, if you guys are kind of catching that again, I thought he said that earlier. So he has to accept the allegations as truth for now, like during this motion to like move forward or whatever, so that's pretty interesting as well. So that's why they don't need to go and I guess into evidence or like pulling out, well, this is why this is why that. This is just like a pre-trial to see if they're going to go forward.
I have to accept it as true that the Laundries knew where the Gabby's body was, and they put out a statement in the middle of the search hoping about the success of that search and then not either directing them or either staying silent.
That's pretty interesting. Thank you, Beaver, for that. And I'm not ignoring you. I'm not trying to ignore you. But thank you for the clip. And thank you for hitting like. I see you hit like on there. The other quick thing I could show before we head out, I haven't even looked at this video. I don't know if there's anything. I don't know if there's an old one.
Blogger Gabby Petito went missing last summer while on a cross-country road trip with her fiancé Brian Laundrie. It was a case that quickly spread across social media and beyond, with citizen detectives latching onto every clue in her disappearance until the day her body was discovered in Wyoming. In part of our crime series this month, senior correspondent Laura Ingle sat down with the police captain in charge of the independent investigation into that now infamous traffic stop that provided critical clues and warnings. In a Fox News exclusive. Good evening, Laura.
Shannon, one of the turning points in this case came when two bystanders in Moab, Utah, told police they had witnessed a violent exchange between a young couple outside a grocery store. It was a month before Gabby Petito was found dead. Police immediately searched out the pair who drove off in a white van and pulled them over, which led to heavily examined police body cam footage of that traffic stop.
How's it going?
It was the traffic stop scene.
I mean, this is all stuff we know. But, oh, shit. I just fucked it up. What did I do? No, I doesn't want to play. Let me try something else. Could be the blocker.
When van life blogger Gabby Petito went missing last summer while on a cross-country...
It was the traffic stop scene around the world.
We just been fighting all morning, and he wouldn't let me in the car before. And then
Why wouldn't he let you in the car?
Thank you, Beaver.
Calm down.
I didn't get overtly physical. I'm just trying to keep her away. I
I was brought in to determine whether or not there were any violations of policy or law and how they handled that traffic stop.
In a Fox News exclusive, we talked with Captain Brandon Radcliffe of the Price City Police Department, the independent law enforcement agency in Utah, which was tasked by the city of Moab to closely examine the city's police handling of the domestic violence incident involving Gabby Petito and Brian Laundrie.
When you arrive on a domestic violence call, you don't have their history. You don't know if what they're telling you is the truth. You have to base what your actions are based on what they're telling you, the evidence, any witnesses.
In his report, Captain Radcliffe said officers should have cited Gabby for domestic violence, obtained a statement from the original 911 caller, and offered several recommendations to the department, including giving officers additional training for domestic violence investigations and legal training so they understand state laws and statutes. That body cam footage was an integral part of the investigation, showing officers struggling with the language of the law, which ultimately led to the couple being separated for the night with no arrest or citation made.
I think they made mistakes in how they should have handled that incident. But to saying that they failed Gabby Petito is to say that they are responsible for what happened. And again, I will not blame those officers for what Brian Laundrie did to Gabby Petito.
And for the first time, the Utah attorney...
There was a lot of people doing that, blaming or saying it was the cop's fault, or like she'd be alive today if they had taken her in or him in or whatever, you know.
Retained by Gabby's family addresses the concerns raised in the traffic stop and resulting report, which reads in part, ultimately, the officer's failure to understand or follow the requirements of the law left Gabby defenseless with her abuser and resulted in the lost opportunity to avoid this preventable tragedy. The attorney representing Brian Laundrie's family had a different take, telling Fox, although the officers may not have followed the letter of the law in not citing Gabby, I believe they did the best they could given the responsiveness of both Brian and Gabby during the traffic stop. We reached out to the city of Moab to ask if any of the recommendations have been acted upon. The city says its officers...
Damn, I didn't even realize we've been here for 2.5 hours. I'm thinking I'm going to do this shit for an hour and a half. We've been here for 2.5 hours. This is the amended complaint, which a lot of people have seen. Maybe we'll go over this sometime. If we come back, depending on what happens, we can go over this. I think I've already looked at this once, but how long this goes. Yeah, I've already looked at this previously. I gotta go get the baby girl now, so I'll save this document for the next time we can look over this. Maybe have a little bit more context. But all right, thank you guys so much for watching. I appreciate you hanging out with me to watch this hearing for Gabby Petito, the families versus each other, I guess. And I'll be following to see what happens next. And we'll be looking into some other stories. I saw somebody in the chat mention too, Marilyn Manson. So that has been discontinued. I was kind of looking forward to that as a trial. I was like, oh, this is kind of interesting. Marilyn Manson. Let's see real quick. Yeah. It was dismissed by the judge. So I was like, damn, I thought that was going to be kind of an interesting one. So in case you're still looking for that, it's not going to happen. Sexual harassment suit against Marilyn Manson dismissed by judge. A judge dismissed a lawsuit against Marilyn Manson Wednesday, brought by a former assistant accusing the musician of sexual harassment and assault. The judge dismissed it on grounds of waiting too long to file the suit. Oh, I thought they said there wasn't enough evidence, but I guess they're saying it was too long. Los Angeles Superior Court Judge Michael Stern heard arguments on plaintiff Ashley Walters' case and said he came to the same conclusion he did in February when he found that the plaintiff had not presented facts to overcome the statute of limitations. But at that time gave her a chance to file an amended complaint. The plaintiff has pleaded too few facts and too late to keep this case in court. Walters worked with and for Manson Records from May 2010 to October 2011 and alleged that the singer sexually abused and battered her multiple times and required her to travel with drugs. She also maintained that he bragged about raping a woman and showed her a video of himself abusing an underage girl. Holy shit. Allegedly. Tanya Walter's attorney told the judge that her client initially repressed her memories of the alleged abuses by Manson due to post-traumatic stress disorder, and then hired an attorney and reported what happened to law enforcement when she recovered her memory in 2020. Wow. So between 2011 and 2010 and 2011, this happened. And so the memories were repressed. And then I guess in 2020, she says that she recovered her memory in 2020. Manson also threatened to ruin her career and reputation, the attorney said. But Walters did not file her lawsuit until May 2021. The judge noted in February ruling, reading the First Amendment complaint as a whole, Walters pleads that she was aware of the actions against her by the time she left her employment. Stern furthermore wrote, thus 9 to 10 years passed until the filing of the action, far beyond the 2-year limitations periods of her claims. Oh, wow. So they got a 2-year limit there. That's kind of on the shorter end that I've heard of, 2-year limitation. Walter's sexual assault cause of action as written is not subject to the most recent amendment providing for a 10-year limitations period. Oh, okay. As this revision is not retroactive, according to Stern, who will set February and again Wednesday that Walter's claims are not subject to the delayed discovery rule. Manson attorney Gene Williams told the judge during Wednesday's hearing that much of what Walters alleged was contradictory and that the evidence showed she knew the alleged abuses were wrong at the time. He also said Walters did not provide proof of any threats by Manson against her, but only that he was bad and scary. Walters came forward along with other women who accused the 53-year-old singer of sexual abuse. Manson's real name is Brian Hugh Warner. He obtained his stage name by combining the names of sex symbol Marilyn Monroe and his infamous criminal Charles Manson. Manson faces personal injury litigation in Los Angeles. Federal court brought by Games of Thrones actress Esme Bianco, who alleges she was sexually abused, drugged, and tortured by the singer. Oh, Lord. A hearing on pending motions in that case is scheduled for Friday. Oh. Maybe that's something we can look into then. Something that'd probably be short. At least the hearing would be short. The law firms representing Walters and Valley Kane and something LLP at Cell Stormer, blah, 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 provided the following statement in response to the judge's ruling. We're deeply disappointed in the court's decision today. If allowed to stand, this decision would drastically limit the ability of victims of abuse to obtain justice through the legal system. We clearly pleaded the facts of the case in the complaint detailing the trauma and abuse Ashley endured, which prevented her from coming forward sooner. While the court based its decision on the timelessness of Ashley's claims and not the merits, we disagree with the court's interpretation of the law as it applies to equitable estoppel and the delayed filing of abuse claims. We remain confident that the full review of the facts in this case will result in successful appeal. So they're going to appeal. We should plan on filing. Walters also released her own statement. Nobody gets to choose exactly how they process abuse or threats. I am disheartened in the court's decision today, not just for my case, but for the messages it sends to other survivors out there trying to balance how they process abuse and arbitrary court deadlines. And they call this shit arbitrary. Your court deadlines don't mean shit. We will not let this hurdle stop us from shining a light on what happened to me and others. So are there going to be more women coming out? And what was this article posted? This was posted. Oh, so this is probably already at May 25th. I don't know. So that one in particular is not happening unless they appeal and then it goes through. Or maybe this other actor from Game of Thrones, which that could be kind of interesting if there's a live stream of that. I don't know what this guy's history is, Marilyn Manson, or how many women are going to come out, but yeah, that's it. Thank you guys so much again for the stream coming through. Beaver said iCkEdMeL there would be another case against Johnny by Rocky. Yeah, during the set said he got him. Camille will be their lawyer. They got nothing on Depp or his team. I think that's not going to be on TV though, from what I hear. So, but all right, man. Thanks. Love you guys. Hit like on the way out. Take care. Peace. Adios. Thank you guys so much for. Oh, I didn't get the super chats. My God, at the very end, I should have got this earlier. Risa, thank you for being a member for 2 months. Say, hey, Mel, hey, chat. You're live. Kay, I got you. Thank you for the membership. Heffa, say what? You were so missed. Thanks so much for the super chat. Amy Winters, thank you for becoming a member. Callie, Sandy, RN, I got your PayPal. Thank you so much. And I also got the ice cream thing. I don't know if it was Cash App. You sent me something. I did buy Maddie some ice cream. Callie says, welcome back. Next visit, North Cali, the wine country. Oh, yeah, that's what I heard about. Wine country. I want to check that out. The Napa Valley wine train. Oh, shit. Is a blast. Missed you, and you look so happy now. Thank you. I was thinking that if I come back, like I said earlier, my analytics shows that most of my people watching are from Cali. So I don't know. I think on another trip, I'll come back sometime and actually maybe like meet people or something. Do like a little meetup, hang out. That'd be kind of dope. You, thanks so much for the super chat. Says, welcome back, Mel. Stay blessed. Thank you. The Jeweled Monkey says, Manson has been respectful every time backstage in my experience. If you also wanted to hoe it out, the band accepted that behavior too. Oh, shit. Savage. Savage. We can be respectful, but if you want to hoe it out, you know, hoe it out. All right, I'm out of here. Love you guys. Peace. Adios.